To mention regarding item number 219 of the monthly. My senior friend is one of the respondent, my lord. He is the worst sufferer. And my lord, I am the for the RPNA. It's the project of the metro rail. My lord, there is a time bound project. Almost yes, yes. Almost matter is hard. So the tendency of the mistake I cannot take. No connection with you. Well, almost matter is hard. Well, any day matter may be fixed. Well, item not Hamilton. Well, item number 219 of the monthly.
I would request you to. I'm going to Jalpai for a certificate next Monday onwards. I'll not be here for 2 weeks. So why don't you mention after they come back?
So, Malad, any day,
Difference.
any day after
Any day
August.
tomorrow and day after. So it will be better if you mention on the when I join. I'll fix up a date and I'll give it. The same thing as I said, I need 2 more working days. Why do you want to encumber the list unnecessarily? Automatically appear in the monthly. Monthly. Okay. So it's a long term list. What is your urgency?
Starting my interest and interest they are making.
I make it very clear today, tomorrow, and day after. These are the 2 working days that I have before going to Jalpai. I have a circuit bench at Jalpai. So I would request you to mention the matters after I come back, because if I just including the list, I cannot take up the matters. Unnecessarily encumbering the list will not help us.
Your Lordship may.
Automatically
give the numbers, please. Call the extension of injury model is for
Your Lordship.
For extension of injury model only.
Your Lordship, may I take your Lordship kind leave to mention a matter? The interim order is expiring on 31st of July, Your Lordship.
Extension of injury model.
And it may be permitted to mention a Lordship for extension of interim order.
Extension of injury model, give the numbers.
Extension of interim order Lordship, it is appearing under the heading Lordship, hearing Lordship. Now Lordship 30th Lordship, the interim order will 30th of the.
Give the numbers. Give the English of extension of injury model. Why don't you? I have just said. Please mention after. That is supplementary list. In any case, it will not be upgraded. Please wait for your turn.
May I be permitted to mention?
Matters will not be upgraded.
Lord, maybe.
It is in the supplementary list. Please wait.
Non-constitutional matter file lying in the court. Third time I am.
আসছে না কেন? হ্যাঁ, কদিন আগে 2 দিন আগে আমি অ্যালাউ করেছি নন প্রসিকিউশন অ্যাক্ট। কালকে টু মেনশন করবেন।
My clerk has said
2 দিন আগেও একটা নন প্রসিকিউশন মুভ করছিল, আমি কদিন ধরে দেখছি এটা আসছে না ইয়েতে। তাহলে পাঠিয়ে সব আজকের মধ্যে।
My lord, may I be permitted? My lord, may I be permitted? My lord, may I be permitted to mention this same motion appearing in the monthly list item
Please
number.
do not mention, because tomorrow and day after that there's a circuit bench. I'm going there. So why don't you mention after I come back?
Monday.
I cannot take up matters. Next Monday onwards for 2 weeks, I will not be here. I have a circuit bench at Jalpaiguri. So I would request you to mention the matters after I come back. I cannot take up matters in these 2 days, isn't it? Please come back after I come back.
The inclusion of restoration application, my lord, same restoration.
Yes. Is there anything? Call the days list, please. What is the correction necessary? Correction. Oh, CPA and CN होगा तो आपका inadvertent error has crept into the order passed on 27th March 2023 in the third paragraph of the order. CAN 28 of 2023 be read as CPAN 28 of 2023. Paragraph, the department is directed to incorporate necessary correction accordingly. This order be treated as part of the order passed on 27th March 2023. Next,
This has come at my instance, my lord. I have put my learned friend on notice yesterday.
you are appearing for the railways.
Yes, for extension of interim order, my lord. Interim order is expiring on 31st of July. Initially, lordship was pleased to fix this matter under heading hearing. Lordship usually takes group 7 hearing on Tuesdays and Fridays. Lordship has division bench on Fridays. That is the reason, my lord, it let it be extended for a limited period.
Your lordship kindly extend the interim order for a limited period and fix the matter for hearing.
I also have the same
the-
prayer, my
in-
lord.
Affidavits are exhumed.
All
Yes,
pleadings
yes.
are complete, my lord.
Any day after 15th of August.
That means
Limited period, your lordship kindly extend the interim order.
Third line of counsels for the parties. Paragraph, let the matter appear under the heading hearing, group 7 hearing on 22nd August. Paragraph, the interim order granted earlier is extended till 31st August or until further orders, comma, whichever is earlier.
grateful, my lord.
22nd and 31st. 22nd August
Lordship.
and extended till 31st August. Yes, what's the correction?
No, this is not correction.
Item 3,
No correction. Matter has not been moved, but correction.
correction.
Probably heading is wrong.
Correction like this, the police.
Correction.
This has come from the department for correction.
No
The
correction.
third matter.
Correction like order to action.
Inadvertent error has crept into the order. Inadvertent error has crept into the orders passed on 14 February 2023 and 22nd February 2023. Paragraph, in the said orders, WPA number 276 of 2022 be read as WPA 276 of 2023. Government directive of the Sovereign has started. Supplementary urgency of the website.
Happened to my matter.
This matter.
276 of 2023.
Correction. Order back. Order. This was not even mentioned. It's appearing for correction from the department. That's all.
My landed friend has
Oh, the
checked
matter has been dismissed for default.
which one?
This matter on
No, may I
22nd
have?
February. On 22nd February. Sent to the department, they have sent it for some correction. That's
Check. Tell it, proceed, my lord, let me check.
next.
My lord, the new application was filed. That's the defect. You also direct the superintendent the responder file to consult regarding payment of compensation. But the contempt application is submitted to the court, Mr. Day. Well, no, responder 2 is the authority. That is why when I paid for leave to file the application file, that will be. I filed. But there is some defect only. You also granted liberty to I withdraw that review application and file the first. That liberty was given. Now problem is, my lord, I have drafted everything. But computer section says unless you enclose certificate copy of that order, you lost your that has to be annexed.
That's the rule.
I know, but that is to be annexed with the original review application. But leave may be granted. I shall take back that. I shall supply certificate copy of the order. Thereafter, I shall file review. That liberty always we get one in the court.
You have asked for this liberty when.
I forgot. No, but it is my mistake. I forgot, man.
Is that the,
I forgot, man. At that point of time.
on prayer of the, you are the petitioner.
Yes, yes.
Former liberty is granted to withdraw the certified copy of the order under contempt.
No. I will.
In order to file a review application.
Lord, and this is another Xerox copy.
Yes, yes. Obvious.
Upon furnishing a photocopy of the said order. That is the rule. It should have been done on the earlier occasion. Paragraph, let the matter appear under the same heading on
আমার বললো যেমন অ্যাপিয়ার করেনি কোথায়
what about the content? It has been complied with.
Yes, my lord.
Oh,
My lord, I have nothing to say, my lord, because my lord, we have sent the matter to the DM to take appropriate action.
But
Yes,
problem is, Sala, if
75
file review application, I shall direct the responder number 2 into the responder 5. That is the problem. That is why you have the case pending the content application. Only direction.
Direct purchase.
Only that direction.
only for the cause of that,
Only
my
that
lord,
case.
the contempt. When DM, the authority, my lord,
Authority.
then my lord, this contempt application will be withdrawn. That is.
Yes, after exposure.
23rd August.
But can I get back that
I have given direction.
from here?
No, I
Sir,
think
it
from
should
the
be difficult to get from the department.
department, not from here, from the department. An endorsement has to be there. You have to file a copy.
Then I shall go to
All that
department.
cannot be done with this.
Then I shall go to department. But you have to get the liberty has been given. Next is the same. 5 also same.
You want to file a review in 5 or
Yes, same.
same order as
Same.
Six. Five. Yes.
My matter never appeared.
Same.
This matter 276 of 2023 never appeared after 10th February. Because my lord's order is interim order even it was never moved. The question of interim order does not appear. One day it appeared, I appeared, your lordship was not satisfied with the service, it was placed on interdible date.
Whatever has happened, the matter has been dismissed for default.
Cannot be,
There is an order.
cannot be, it never appeared. This is of 2022.
That is the mistake which I have
That is
corrected.
not the mistake. Kindly see your lordship's order.
Make it
My lord normally looked into the papers, then passed an order. My lord has said interim order if any stands vacated. There is no question of any interim order.
Exactly. That is the usual
No,
order.
my lord has looked into the file.
No,
Then,
not at all. While dismissing, we don't look into the file.
my lord, your
That is
lordship,
the
kindly
usual order that is passed.
see this order. Your lordship's order.
None appears.
When none appears, my lord is to adjourn this matter. And before that, service upon all the respondents not complete.
In
Let
the
the matter appear on 18th January 2023. On that date, it appeared item number 10, item number 75 in code number 10 on 14th February 2023. It appears my lord has adjourned this matter.
after that,
Thereafter, my lord, this matter according to our calculation never appeared. And both the orders are of 2022.
that is the mistake that has been done. It's a typographical mistake. In two
Continuing,
orders. In two orders, that has been corrected.
probably it is incorrect.
So file an application.
If my matter is never dismissed, my lord, should I file an application?
It is dismissed.
Let me check, my lord, the
That is there.
list on that date. If on this date, on 22nd February 2023, item number 74 is not this matter, 276 of 2023, then question of dismissal of my matter does not appear.
I feel it is the same matter.
Let us check
It's a
up, my lord.
typographical mistake that has been done. That mistake has been done by my airport.
Whatever may be. If it is a mistake, no problem. But if it is not appeared at all, and this matter was dismissed,
Please file it.
let me check up this list, then it will be clear.
That is Same order. That's it.
My lord, I am for the contempt matter. I if you appear for the petition, last petition, you lost to directed to serve, my lord, I have.
Compliance.
Yes, complied by my lord, every bit of compliance is not up. So my lord, I pay sometime, my lord, I fail to understand why for compliance have to file a contempt and then ask for complaint. But I do not know, but my senior friend is saying it's compliant. Must be
Please come
compliant.
back with your evidence of compliance.
Yes, my lord, only for that reason I pray. In this court, always you must file the.
It is submitted on behalf of the alleged contemner
What
that
is
the
the
order
certified
under
copy?
contempt
The
has been
certified copy?
complied with. Learned counsel seeks to submit an affidavit of compliance on the adjourned date. Paragraph, let the matter appear under the same heading. On 24th August,
Because I have to challenge that also because it's already late.
I
1 year.
have a circuit for the next 2 weeks. Jalpaiguri.
এই যে এটা দেখে যাও
Malad, there are two applications, Malad. One is can for additional parties, Malad, and can two for vacating of interim order that is filed by me, Malad.
But my lord, today we have everyone's room. I would start on with my submission. My lord, can one is my application. My lord,
Yesterday, one of the, I think
My lord,
Ms.
she
Joy
was
was
not
not
there.
there.
She was not there. My lord, can one is my application. My lord,
We think that can one, that affidavit or not?
my lord, on the last occasion yesterday, my lord, my learned friend was harping on the fact that I am not a necessary
And
party or a required party.
Two দিবেন, two না।
But
One
the
এর
proper
opposition আছে, reply আছে, affidavit এর opposition আর reply আছে, can it? Yes, you can start.
My lord. My lord, yesterday the main substratum of his submission, my lord, as I understand, is that I am not a necessary party or a proper party, hence not required in this writ application. Now, my lord, the reason why I am here today and why I am espousing the cause for being added as a party is very simple. My lord, I am basically a person who had taken part and qualified in the tender process, which was floated by the National Highway Authorities of India, the respondent before your lordship. Now, my lord, there I had participated, and based on my participation and after understanding that I am qualified otherwise technically and as well as my lord the commercial bid after qualifying, I was given the contract. Now, this contract is to what extent to maintain the highway in its proper form and also to ascertain that there is no damage which is caused, and if it is, immediately to repair the same. And also, my lord, to ensure that the asphalt coat which is there, that is also written in its proper form. Because if that is not there, my lord, the automatic ditches will come in, and that is again going to inure to the occasions of repeated accidents in the highway. Well, that is the reason why this stretch, the entire stretch of few kilometers, were assigned to me. So this is a part where, my lord, he has nothing to say
That
because
is
it's
primarily maintenance of the highway.
maintenance of the highway. Well, this is the part, my lord, because of which he is saying that I am not a required party. Now, how is it that I am required party? The reason is, my lord, today they have come up before your lordship with a particular land in question where they were given by the state government. My lord, the state authorities have assigned them that land. We are not really into that. My lord, that is the Kapasaria stockyard, my lord, which they have said that this was given to us, this, that, and various other allied things. Now, that is the merit of the writ. I really cannot get into because today I am here for addition of party. Now, my lord, what I am on is that, my lord, a stretch of 150 to 145 meters directly starting from the highway and getting into the area, my lord, which is otherwise not that well paved road. So that part in the entire stretch is, my lord, belonging to the national highway, and that is given as a part of the land where we are supposed to set up our entirety, including the raw materials, hot mix plant, and every such other amenities and instrument and equipment, my lord, to facilitate the maintenance of the highway. Now, this Capasaria highway plus this land is the issue, my lord, for which I am here, because they had put a boundary in excess to the land which was there given to them by the state. Now, that portion is of the highway which was allotted to me, and I am basically in possession of that particular stretch during the tenure of my contract period. And I have also set up my things because every, my lord kindly appreciates, if we have to maintain a stretch for a particular stretch, there has to be an immediately the raw materials has to be put in, because if that is to be carried from a distance, by the time it comes, the quality will deteriorate, because that will cool down to the limit which is perhaps not the required.
You are concerned with the national highway, the road.
I am concerned with that. And now, my lord, where is it that I am affected?
Petition is not with, has no connection with the road itself.
My lord, road and the area
The
where we
adjoining
implement
area.
the
This
setup.
petition is concerned with the adjoining area.
It
Isn't
is with the Kapasari stockyard, but they have encroached into the land of the national highway. Now, my lord, what has happened?
My case, ma'am.
Now, what has happened, my lord? There are things which are already installed by me, which I go to use it because definitely that is required for the maintenance. One after another, my lord, they are initiating criminal case against
Your
my
things are
employer.
installed on the national highway or on the adjoining
My lord,
land?
kindly comes to my application. I have made a sketch.
Prima facie, you have no right over the adjoining land.
My lord, prima facie,
You
I
have only to deal with the maintenance of the national highway,
the
the
national
road
highway.
itself.
My lord, kindly comes to page 18 of my application. These are all the documents which was given during the contract. Annexure B, page
Yes,
18.
yes.
My lord, this is the LA case number based on which, my lord, the national highway acquired that land, which was allotted to me. My lord, kindly comes to page 19. These are the stretch of lands, the areas with plot numbers, Khotian numbers, which are in issue. Now here, my lord, this
This is the position taken by the national highway.
No,
Page 18,
no,
page 18 is national highway.
no.
position was handed over to the national highway, to the requiring body.
This
Acquired,
is the acquisition of the national highway, my lord.
this is not the acquisition by.
He will have his chance.
Yes, yes.
If he is wanting to, argue for me, I don't mind. My lord, page 19, my lord, is the details of the plot of land which are appended with the national highway main stretch of the road
Yes.
for my lord maintenance of it. So this is something which is given. Kindly sees my lord, page 19.
Yes.
And these are the entire areas which are given to us for setting up our equipments, raw materials and all. Now, my lord, I turn the page. The details of the tag number and all is provided here. That is page 21.
This area was given to the national highway, not to you.
My lord, National Highway has given it to us.
Where is that document?
My lord, that is the tender. This is what is the part of the tender document, my lord.
Where is the tender showing the exact area that has been handed over to you?
My
For
lord,
maintenance?
the exact areas which are handed over to me, my lord, these are the entire plot of land. This is a part of the tender document. I have it. It's a bulk document, my lord. I can hand it
How
over
do
to
you show that you are interested?
My lord,
There should
national,
be some document of entrustment.
my lord, that the National Highway can say best, my lord, the National Highway is already representing. Now, my lord, what I am on is, my lord, kindly see. I'm taking
Because your
lord.
entire case lies on the anvil of entrustment, isn't it?
Yes, my
That
lord.
is how you want to
No,
come
my
into
lord,
the
not that.
petition.
Because of this entrustment and for the purpose of operating the tender, my lord, I have to use that land. Because I
That's
cannot
why I want to see the
relocate.
exact conditions of the tender. What exactly was entrusted to you?
My lord, that we have that particular land. Basically, it's
The
a
document,
license.
the document.
My lord, only thing, my lord, in that if your lordship wants to see the entire tender document, we can hand over.
No, the relevant part where
My lord, kindly come to
have
page
been
30
given
once. 30. I think that will be easier for your lordship. 30 of my application.
Yes. Yes.
My lord, the subject matter of my learned friend, I understand, is the Capacity Stockyard. That's my lord encircled region. Your lordship can see the top region. My lord, this stretch, my lord, of 160 meters, 145 meters, 150 meters towards the Mohishadal Road, my lord, which your lordship is seeing. This is, my lord, the stretch where, my lord, we are given for keeping all those things and getting the raw
But I
material
want
done.
to see, how have you been given? Not verbally, of course.
No, my lord, it's a part of the contract.
Where is that part? I want to see that. The exact entrustment, the exact,
My lord, I can, in this particular application, my lord, the documents which we have annexed.
you have to substantiate that you have some interest in respect of the plot in question, isn't it?
My lord, kindly see page 24.
Because page 30 doesn't, is neither here nor there.
My lord, that is the sketch map for understanding because this black mark is the highway. And this 150 thing is, my lord, the area which is for the maintenance of the road, which constitutes a part of the tender, and my lord, the plot numbers are all mentioned here. The details in page 19, 20. My lord, these constitute a part of the tender bidding document as well as, my lord, the
Page
tender
19, 18, these are all documents of the NHAL.
of the original tender.
Requiring body. How are you involved? That is
My lord,
what I
these
want
are
to
the
see.
documents which was
These
given.
documents don't involve you at all.
My lord, may kindly come to this letter, my lord. I think this letter will otherwise clarify because page 24, my lord, kindly see.
Page
24.
This is to the project director.
Project National Highway, because this is the authority who had given the tender. I am to first report to them.
And this is your client, Kolaghat Holdia,
Yes, my lord.
OMT project.
Yes, we are working as concessionaire for carrying out the operation and maintenance of the above mentioned project starting from the year 2017, period of 9 years. We have completed the first BC, that is bituminous component, my lord, overlay. That is the asphalt part, in accordance with the concession agreement. And now the mobilization of second bituminous concession overlay is in progress at the above mentioned project. For this, we have selected the suitable land for installation of the hot plant at Capaceria from CH 37 to 100 plus 100 to 37 plus 260 LHS, which comes inside the National Highway Authority row. where the row is 150 meters from the central line of median. But an encroachment is already situated at the proposed location for HMP. The details of the enclosure are as below. In view of the above, the Executive Engineer, National Highway Division 2 has already served the notice for vacating the land before such and such. The concerner would like to invite the kind attention of the authority towards the concerned letters dated such and such, where the concerners had submitted the details regarding the encroachment and action taken by the concessionaires for the removal of the encroachment across the project stretch. Now, my lord, this is the details of the letter. And my lord kindly appreciates in furtherance to that, page 31. My lord, we have also been marked down. Page 31. My lord, this is the letter, my lord, which has taken cognizance of our complaint which we had made. And my lord, this is written to the Superintendent Police Midnapur because they are actually encroaching it. My lord, kindly sees operation and maintenance of Kolaghat Holdia kilometer 0002 kilometer 53.472 of National Highway 41. Total length is 53.472 kilometers, including the incomplete section of ROB come flyover from chainage to kilometer number such and such to such and such. And my lord, what is the subject of it? Request for extended necessary police support for removal of the encroachment of on NH land at kilometer 37 plus 210 RHS. My lord, if I just keep that as it is and come back to my letter which I had just read across, my lord kindly sees once again, just for the sake of repetition, my lord. My lord, again I come back to 24. My lord, 1, 2, 3, 4. The fourth line, my lord, from the start of the letter. For this, we have selected, my lord. We have selected suitable land for installation of hot mix plant at Kapsaria from CH 37 plus 100 to 37 plus 280 LHS. The same thing. So it is a fact, my lord, that these were allotted areas for us. It is not that we have any sort of agreement or anything. It's an allotted area for functioning in a proper manner. And now, my lord, where is our predicament? We are nowhere, no one. If I go by Mr. Betal's words, my lord, in one after another criminal cases have been initiated against us. They say that I enter into their land, I enter into, my lord, if I go to collect my things, my lord, they are coming up with a criminal case. My employees are suffering, everyone is suffering.
Does that have any connection with the present writ petition?
Present writ petition, my lord, if your lordship
You can place your case before the criminal court.
True, my lord. But my lord,
The
if I am
present writ
not a
petition
party
is
here,
primarily for removal of encroachment.
my lord, what it is, my lord, if I am not a party here, my lord, the entire gamut is that whatever is the encroachment is the reason for what they are doing. Now, my lord, encroachment is what they have done, and I am being affected because my work is being affected. One, I have to subsequently suffer for that the damages.
The
And everything.
NHI will take care of that. It's between you and the agreement is between you and the NHI interstate. Petitioner has nothing to do there. Petitioner is, according to you, an encroacher. NHI will take necessary steps. Petitioner has come up against that.
My lord, the only thing
Petitioner
is
says
that
it is my land, the NHI cannot remove me. NHI says otherwise, right? So what is your role in the writ petition?
my lord, my
You have
role is my
informed
lord.
the NHI, you have informed the police, the NHI has also supported you there. So it's between you and the NHI interstate.
True, my lord. But my lord, the only
The
thing
writ
is that
petition
my
will
lord,
decide a different issue altogether.
my lord, the only thing is that
You
if
are
I
on the
am,
consequential part.
my lord, I am the consequential part because I am suffering and one after another things are being done against me. One. Second is, my lord, I am the affected part. Might not be that I am the necessary party or proper party, but my lord, I am the affected party.
Yes, ma'am.
Now, if I am the affected party, then definitely
party.
because my employees, they don't have anything to do. They are just performing they are discharging their function. My lord, just because they have kept the land, they have encroached the land or whatever, my lord, that is definitely your lordship will take cognizance of it. My lord, if I am added in this particular writ application, well, perhaps I can give the input as to what is the practical thing which I am facing there because I am working. I am working in that area because I have to maintain and operate the highway.
But we are facing the negative recurring, my lord, because of this, my lord, encroachment.
Yes, the NHAI can respond to this. I was wondering how the proposed added respondent will have any.
My lord,
role to play here.
my lord, subject to
Because
my
it is
learned
the
friend's
NHAI.
correction, my lord, because there is some agreement, lordship, there is time-bound agreement, my lord. There should be a time-bound
I want to
agreement
see
between
that.
this.
I have asked, that's why I wanted to see that time bounded, whatever you say, time bounded agreement.
My
Well,
lord,
that
that
is
is
the-
And the
then I have
council
to
says
say-
there is no agreement at all.
My lord, that means, my lord, the time-bound agreement, my lord, there is then, lordship, there may be a verbal agreement, my lord, whatever may be, that should be, lordship, taken care of within such time.
Where is
It is-
that? I want
My
to see
lord,
the
I
document.
agreement, but it is not because this is something, my lord, which is.
Because I fail to understand how your rights are being affected, because you have informed the NHAI. NHAI has appointed you. It's an agreement, if I call it an agreement, it's between you and the NHAI. You have informed the NHAI that I am not able to perform my part since the encroachers are not allowing me. Right? So the encroachment portion is being dealt with in this writ petition.
My lord, that is
Whether
with
or
respect-
not he'll succeed, or that's a different issue altogether.
My lord, that is one part of it.
Because as a consequence, you'll be allowed. If the NHAI succeeds, you can continue with your work. If
My lord, the
not,
only thing is that, my lord,
not, you will have no authority.
my lord, only thing, my lord, I am a person who, as per your
You
lordship,
cannot add to the contention of the writ petition
my lord, I
or the
cannot,
NHAI.
my lord, I cannot add is one part of it, but the fact is, my lord, that I am being affected every day because of the conduct of the petitioner.
Oh, you
Because
affected.
the petitioner is going and initiate, and it is their averment that they have done this, they have done that.
That's a
My lord,
different
they are pulling me in.
cause of action. They are pulling you in some other case.
In
You,
this
you
particular
can
land.
participate there.
My lord, every time they are pulling me for this land. It is not that for anything else.
There are other authorities, my lord, the police authorities are there, they are looking into
My
it.
lord, in any event, my lord, my being added as a party, and if my lord during the course of
To
argument,
be a necessary or a proper party and be affected by the decision taken hearing. I prima facie do not find anything. So if you want to come back with documents, you can.
very well.
Firstly, the agreement is not there. I cannot find anything here that says that you have any responsibility whatsoever with regard to the land in question. I find 2 letters which say that you are not able to maintain. If that be so, then NHI will take a call. You have informed them that due to the petitioner's encroachment, you cannot do anything. So there is no question of your being affected by the result of this petition.
My lord, they are
If you want
actually
to come back with documents, you can. They are pulling you in other criminal matters, maybe.
and
You
my
can
lord,
participate in those matters.
my lord, the
That doesn't
reason as to
necessarily
why
mean that
this
you can
criminal-
join in the writ petition.
My lord, my joining in, I don't think is going to affect them in any way.
That's not the question. Affecting is not the question. You need to be, you have to
But I am being
substantiate.
affected, my lord, because of their conduct, and they are taking your lordship's order, the interim order which is granted. It is also stated in their affidavit that this is what is there. You are getting it. You are doing this. You are doing that.
So if there is an interim order, do you think you can get in to that land?
My lord, getting into the land is one part. I am
That's
getting
the
into
reason why
land
these
is some-
complaints are being filed against you. That's the reason, isn't it? So this has to be dealt with in the writ petition. I do not understand still how addition of party will really help. So if you still want to come back with documents, you can.
My lord, if your lordship wants to see.
I'll
the
hear out the
contract
others
of-
also, of course. These are the questions that are disturbing me.
My lord, because it's a contract terms, my lord, we did not annex it here. But that it is time bound, my lord, if your lordship allows me, then only that portion that
Because
is
learned
entire
counsel
thing,
says it is time bound.
it is. Because it is basically for the maintenance. And
So
that
how can
maintenance-
a continuous maintenance be a time bound contract? That also I
My
don't
lord,
understand.
because there are certain time limits which are framed for the first overlay, then the second overlay. Because if the scheduled overlay doesn't take place within the scheduled time, that is
The
actually.
road
going
is
to-
complete.
Yes, yes.
So now it is only
lord,
maintenance.
The road is
No, my
there,
lord, that-
and every time, during this entire stretch, my lord, what is done, my lord, the highway has to be maintained by doing this overlay work,
That is
so that-
maintenance.
maintenance.
The
Now,
road
my
is
lord-
ready. It's not construction now, it's maintenance.
No, my lord,
The
national
construction
highway,
is
my
there,
lord.
my lord. Well, construction
This
is
is the
going on.
Haldia
No,
highway.
my
Yes,
lord.
yes, it is over in 2012.
This is the Haldia National Highway, my lord.
2012.
No, that is
Thousand
Kolaghat
years.
to Holdia, my lord.
So that the national highway is there already, it's existing. If it is maintenance, then I don't know how can it be a time bound contract? In case of continuing construction, it can be time bound. But in
My
case
lord,
of
even-
maintenance,
My lord,
it is as and when, isn't it?
My
No,
lord,
no, no.
Because,
Subject to
my
lordship,
lord,
no.
with respect to the miniature works, my lord, where we really do not need to set up the hot mix plant. My lord,
That is
those
the
can be tackled all through, and that is a continuous one. But with respect to the overlaying work, my lord, that is scheduled because this is the first tenure when you have to do the overlay. This is the second tenure when you have to do the overlay. Because this
Season wise,
overlay, my lord, is something which keeps the road in its form. It doesn't actually get it damaged. Because if it is not done, then the subsoil area will be, because it's a bit of engineering though, my lord, but the subsoil area will be damaged. If it does, then the road will go, no, the entire road that will have, my lord, different levels. So those things, those waves which will come to the road, that is going to again hamper, because this is something which keeps it intact all through. And there is scheduled time within which this overlay things has to be done.
Please come back with the document showing that it's a time-bound agreement. What?
My lord,
As you say.
do I need to give the entire document or only that portion?
Entire
that
document
page?
must be a voluminous document,
It is a very voluminous,
not necessary, just the relevant parts.
very well, my lord.
To indicate that you have interest in this matter and your interest will be hampered if you are not added.
Very
To
well,
that extent only.
very well. My lord, then in that even we shall file the
To
affidavit.
come back with a supplementary affidavit. Please serve copy in advance to the others.
My lord, we shall.
If we wish, my lord, you can, my lord, file an affidavit to that.
Against that supplementary affidavit.
Of
My
course.
lord, that is one document which we are
Because,
going to
my lord,
rely.
their stand, my lord, has not been supported either by this National Highway Authority. I will come back, my lord.
So, my lord, lordship, my application is there, lordship, for this vacating of interview. If your lordship kindly allow me, lordship, I can produce some important parts. If your lordship kindly allow this is can two. Lordship says two can application. Lordship will heard analogously, my lord. My app.
Yes, but this has to be heard first, isn't it? The addition of party.
No, lordship, we are suffering, lordship, because of this stay, my lord. We are suffering, my lord.
Nobody is suffering.
Lordship, we are suffering.
Kindly have a
Lordship,
look at the
kindly
photograph.
allow me, lordship.
What they
On
are
one
saying,
hand,
fail
my
to
lord,
understand.
my lord, on one hand, they said,
Particular-
sir, bole nahi, sir. My lord, on one hand, they said, they admitted, my lord, only there, my lord, this is the dispute, lordship, per se, in between the writ petitioner and the state. But lordship, they have the encroachers, my lord, the writ petitioners have caused encroachment and is illegally occupying, my lord, some portions of the right of way of national highways, my lord. On the basis of that, lordship, once it was found, lordship, upon periodical inspection, there's some encroachment. Lordship, we served a notice of as per section 26 of section 2. After that, lordship sent a letter for reminder, but lordship, they said they chose not to appear. After that, lordship, they served, lordship, one contempt notice. Lordship, they said one contempt notice, lordship, kindly, lordship, come to my applications. That is page
The
42.
interim order says no coercive action.
Yes.
My lord, that is the subject plot, my lord, because they said,
And that is the subject matter of the writ petition also.
yes, my lord.
So if this order is vacated, the writ petition becomes infructuous.
Lordship, my humble submission is, lordship, if your lordship kindly modify to some extent, because lordship, because if your lordship kindly allow me, lordship, to lordship, not to restrain them, to not to participate in these proceedings. Because lordship, with the advantage of this order, my lord, they did not participate in these proceedings.
Which proceeding?
Lordship, our 26 subsection 2 proceedings. They said, well, kindly come, lordship,
What
page
will be the
42
culmination
of
20?
my application. They said that since your earlier aforesaid notice dated
As
16 January
they are, my lord, taking over-
notice dated 16 January 2023 has also been challenged in the said writ petition by way of supplementary affidavit. And upon perusal of the same, when the Honorable High Court passed the said interim order, which is valid till such and such, and when the Honorable High Court, by granting the aforesaid interim order, is adjudicating the entire matter, reissuance of the above referred notice dated 24th March 2023 is nothing but an attempt to flout the Honorable Court's said solemn interim order. Well, on one hand, lordship, if subject to lordship's correction, this order does not restrain our lordship to take the initiative as per section 26(2). But lordship, they take this advantage and serve the notice of threat of contempt, my lord. We are facing these problems, my lord. If your lordship kindly modify to some extent.
Not a contempt notice, and notice itself has been challenged. The 26(2) notices are
Yes.
challenged.
Yes, my lord.
So how can you proceed with the notice?
Yes.
That's why, lordship, I am filing this application, my lord. This plot, my lord, this subject plot is nothing with this writ petitioners. But this is the adjoining plot. It is the adjoining plot of
That
the
has to
stockyard
be
land.
That is the matter of adjudication. That has to be adjudicated. Isn't it?
My lord, my humble submission,
said
lordship,
it's
this
not-
is for this purpose, lordship, I am filing this vacating of interim order, my lord. So this can application is only for this, my lord.
At the moment, it cannot be vacated.
My
let
lord, my
the
humble submission is
applicant
Honorable
come
Supreme
back.
Court in several occasions says, my lord, when there is a question of any public importance, my lord, the stay cannot be granted, my lord. I have this judgment, my lord.
Approach the appropriate forum in that case.
My lord, I am filing this vacating of interim order, my lord. Kindly
Not at
record
this-
it my submissions
not at
otherwise,
this
my lord.
stage. I'm not dealing with the application at all now. Because this application has not been heard as yet. I have to
My
hear
lord,
out can
my
one.
case is only for the
Third learned counsel for the applicant / intervener. Paragraph, the applicant intervener seeks to file documents to substantiate that the applicant has entered into a time-bound agreement with the NHAI for the purpose of maintenance of the national highway and is a necessary and proper party to the writ petition. Paragraph, let the matter appear under the same heading on 21st August.
my lord, my application, lordship, kindly lordship heard and lordship pass this order because lordship,
I
if
have not heard at all. How can
My
you
lord,
pass
if
an
you-
my lord, my humble submission on the last occasion, my lord said that these two applications has been heard analogously, my lord. On the last occasion, lordship.
I hear half of an application and take up the other application for a half hearing. Analogously means one has to be completed and then I'll take up the other matter. You must understand, madam.
My lord, interim order is up to my lord 31st.
It is extended for a limited period of
My
time.
lord, kindly record.
Paragraph, the interim order granted earlier is extended till 31st August or until further orders, comma, whichever is early.
Much obliged, my lord.
Next, please come back with all the relevant documents so that we can deal with them.
My lord, only that part which is dealing with the time.
In those
bound.
documents, we will not support hard to add as
Let us
party.
see, let us see.
Yes.
You cannot make a submission in
obliged, my lord.
advance.
Sir, I am hesitating to intervene. What atmosphere was there?
Absolutely not.
That I know. My lord, I find
Much obliged.
absolutely wrong matter appeared in the court. In the list is here, my lord.
Now, an order has been passed,
In that matter.
rightly or wrongly.
In that matter. These award matter never appeared in the court.
List-
What is it inserted here? Can you be sure that the matters is in the list? This is my lord non-application of mine who recommended for correction. This is non-application of mine. Can you see?
ওই অর্ডারটা দরকারই নেই রাজীবকে বলুন অর্ডারটা না করতে হয় এই অর্ডার সিদ্ধ করতে হবে এটা এটার নয় এটা তো বের করি কিছু দেখি অর্ডার সিদ্ধ বের করে দিই করে এটা মোশন স্টেজে হ্যাঁ করে এটা মোশন স্টেজে রেখে দিই লিস্টে
Here has no fault. Because the matter which appeared here, but how our matter has been tagged in this. Then, my lord, this matter is not yet been moved.
I'll fix a date. I'll fix a date at the motion. Before 2 more days. Not
No, sir, nothing, no, sir.
It'll appear.
Only calling for a report, nothing
It'll
else.
appear in the list.
There will be no interim order I will be praying. Only calling for the
It'll
report.
appear in the list.
I cannot work with my lord, it's the problem.
Just 2 more days, Mr. Basi. You must understand.
It is nothing to be hard. I will be praying for a report so that it
To
can
be
be explained.
included in the list, let us see if I can reach.
As you know.
Next. The motion is included in list.
May it please your lords. I'm for the petition. May it please your lords, I'm for the petition.
Mr. Mandal is appearing for the state. Yes, Mr. Mandal is appearing for the state.
I'm for the petition. Petitioner, an old lady of many diseases, is a resident of mere municipal lane. Kindly come at page 15, the voter ID card. Address,
Who is appearing for the national highways?
yes,
Union of
yes, my
India.
lord, we have served.
Where is your service?
Yes, my lord, I have submitted the affidavit of service.
Howrah Municipal Corporation civil respondents. Ms. Roy is here. Anyone for the national heritage who appears usually? She was here just now. I could have requested someone to appear.
We have served everybody.
Yes?
We have served everybody. All the respondents have been
No,
served.
no, that's true. It's, yes, yes. What is the matter about?
Yes, ma'am. May I please your lordship. Petitioner, an old lady, is resident of Howrah Municipal Lane. Kindly come at page 15. The address, that voter ID card, 3 Shekhpara Lane, 1 of 32, Howrah Municipal Corporation, Chatterjee Hat, Howrah 711104. Now, my lord, similar address appears at all other subsequent documents like Aadhaar card as well at page 17. Nevertheless, petitioner had been served a notice from National Highway under the allegation that you are occupying the land as an unauthorized occupant, a bolt from the blue. Kindly come at page 20.
So you say that the voters card and all, they confer title?
I'm not about title. I'm about her address, the plot wherein she is residing is mere municipal lane that no way comes under zone of National Highway, which is a government land, because under the very Howrah Municipal Corporation Act 1980, all government lands are exempted under section 160 subsection 1. That point I had taken in my pleading. Now coming at the alleged hearing at 21st June, which was held, it was a fake hearing because there had been no chance of production of any document. And number two, there had been no written order, not to speak any reason order, only get lost, they declared. Now every day they're knocking at the door. Kindly come at para 3 and 4 of my petition.
I think because your allegation is primarily against the national highways.
Yes, my lord.
So we cannot hear the matter in absence of the national highways.
Only I'll pray for a direction to consider. Let all the parties be present there, including Howrah Municipal Corporation.
There, may I request you to appear in this matter? National highways has been served.
Well, I don't have any copy, my lord. I don't know. the
Please
matter.
give her a copy of the petition. She is only asking for consideration of her. Where is your
Yes, ma'am.
representation?
Pardon, kind.
Representation.
Yes, ma'am. Representation at page 27. I have made two representations. One representation is regarding the hearing, and another representation if rehabilitation is possible. That is at page 21. So kindly consider page 27.
These are all demands of justice,
Yes, ma'am.
not representation.
Sorry, demand of justice petitioner actually is very old, suffering from many diseases, and moreover, she is illiterate person. That's why she immediately could not contact any lawyer.
She has contacted lawyers for.
Later on, when everything was over, the hearing was over.
There is a representation by the petitioner. There should be a representation, not a demand of justice, isn't it? Will you submit a comprehensive representation before the authority? That will be dealt with by the authority.
आगे कोनो दिए
Affidavit of service. None appears for the National Highways Authority of India,
Must be defended.
comma, the Union of India, and the Howrah Municipal Corporation, despite service. Paragraph, Ms. Roy, who is present in court and is usually appears for the National Highways Authority, appointment regularized for me. Your appointment will be regularized by
The authority, by the National Highways Authority.
National Highways Authority of India. Huh? Be regularized by the National Highways Authority of India. Copy service direction. Well, the petitioner claims to be in possession of the plot in question since long and complains that the National Highways Authority of India has served a notice upon her on 15th June 2023 alleging unauthorized occupation of the plot. Notice upon her open under section 26 within bracket 2 of the Control of National Highways within bracket Land and Traffic bracket closed Act 2002 on 15th June. Huh? First stop. Pursuant to the said notice, the petitioner appeared before the authority, but no order was passed.
No written order.
No order was passed by the authority. Upon hearing the petitioner. Stop. The petitioner seeks to submit a comprehensive representation before the concerned authority requesting the authority not to disturb her peaceful possession in respect of the plot in question, and also for her rehabilitation stop. Paragraph, it is submitted on behalf of the National Highways Authority of India that who should consider?
My lord, the respondent number 2, my lord, project director.
The second respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the writ petition is disposed of with liberty to the petitioner to submit a comprehensive representation ventilating her grievance before the second respondent within 7 days.
Yes, please.
Within 7 days from date. Stop. The second respondent is directed to consider and dispose of the representation within 1 month.
Within a month.
Within 1 month from the date of receipt thereof, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Paragraph, it is made clear that this court has not gone into the merits of the case, and the concerned authority shall be at liberty to deal with the representation of the petitioner independently and without being influenced by any observation which may have been made in this order. Disposed of. That's all.
Also, meanwhile, not to disturb the position of
Otherwise, my lord, not
Pending
recorded.
disposal of the paragraph, pending disposal of the representation, the respondent
Not recorded
authorities.
this, my lord. Otherwise, my lord, I am taking some solicitor. Lord, just now, Lord, received this brief. Lord, kindly not recorded this, my lord.
I'm
Other,
not recording your submission, it's the court's order.
otherwise, Lordship,
Till the representation is disposed of,
Lordship,
the concerned authority is restrained from disturbing the peaceful position of the petitioner in respect of the plotting.
urgent justice.
7 days a month.
Make good.
I am paying for short-term employee lordship. Mr. led by Mr. Gautam, he is appearing in this code number 8. Lordship. I am
I don't think he is in a position to
kindly lordship password the matter.
specify that.
Yes, ma'am. Western Estate Act they enact. Against that, my lord, they file appeal. Their title should file, and after that, that is paragraph 8, my lord, page 8, paragraph 6. Page 8, paragraph 6. We are, my lord, we have to consider.
Not today. Not today. Item 11.
I'm praying for an adjournment, Your Lordship, on behalf of Mr. Shiloshatta Banerjee. He's appearing for the petitioner.
Mr. Siddiqui for the
Like in courtroom number 8, I'm praying for short passover.
Passover is not possible.
Your Lordship kindly keeps it on Monday.
Not possible. On prayer of both the parties, the matter is adjourned. Let the matter appear under the same heading on 25th August.
Grateful, Your Lordship.
Uh, 12 I am for the Jilla Parishad.
My lord. In case of the petitioner, we have.
This is
My lord,
the
we-
report, my lord, which I.
Petitioner's premises is adjacent to the Blacktop Paka Road.
You're for the
And-
private respondent?
No, I am for the Jilla
I am
Parishad.
for the
And
private respondent
on
number
the
11.
occasion,
The
your lordship-
property belongs to the Jilla Parishad. My lord, it was leased out. My lord, now he is trying to
My lord, earlier occasion,
claim
your
that
lordship
property
created
by
a
way of
file
inventory rights.
report in the form on affidavit. My
Right.
lord, kindly see the affidavit. My lord, it is not,
I am for the private respondent,
Private
lordship. 8 to 10.
My lord, I am for the
Seven
8 to
still, my lord, this property is not, my lord, leased out to the, my lord, private respondent.
So
And
how-
they are submitting before lordship that is leased out. My lord, kindly see,
Is it your property?
my lord,
The land belongs to the petitioner? No.
no.
The land belongs to the Jilla Parishad admittedly.
Land belongs to Jilla Parishad, but my lord, even if it is in the government land, my lord, petitioner, my lord, has every right to use the frontage as his ingress and egress. Every right. My lord, so many judgments are there. My lord, if a riot has,
Can you stop the government from allotting a land to another person?
my lord,
Can you stop the government from allotting a land
no,
to
no.
another person?
no. That does not mean, my lord, in front of my premises, my lord, they will, my lord, leased out to another person. My lord, they can list out. I also.
So you're on easement, you have to
Let's
go
sue.
before the appropriate forum.
Civil code.
No, my lord, after all, they have not leased it out. My lord, kindly see the, my lord, kindly
My
see
lord,
this
So
paragraph.
far as the
three.
ingress address is
Paragraph
concerned, the
3.
petitioner,
You're appearing for?
I'm for respondent number 11.
My lord, kindly
Already
see,
there is a road
it is
by
not,
through which, my lord,
Free access
get
is
an
there,
ingress
it is not
for the
leased
purpose
out.
of ingress and
Now he
access.
wants, my lord, the entire frontage has to
Let
be.
us hear the petitioner. Yes,
My lord, kindly see paragraph 3 of the,
report,
my lord, report.
yes.
My lord, in that regard, one inquiry was held. And my lord, it was come out that the said plot of land was being approached by the private respondent for being leased towards the private respondent. And accordingly, private respondent had deposited the requisite money towards that lease, and Jilla Parishad had received the same, and for which required receipt had been issued. My lord, no lease deed is, my lord, annexed with this deed petition. Only they have issued, only they have annexed.
They have said that they will execute. They have not said that they have executed.
They have executed. My lord, kindly see when they have, my lord, deposited the money. My lord, kindly see the date of the receipt. My lord, page
Yes.
6.
Yes,
Page 6, 7, 8. My lord, 21/3/2023. And my lord, the petitioner filed this writ petition. My lord, kindly see. First of all, my lord, he made a representation before the authority. My lord, subdivisional officer, my lord, kindly see page 2034. My lord, 14/10/2000. My lord, 22. 22, my lord, page 33 and 34. My lord, the they have made a representation before the subdivisional officer, my lord, 14/10/2022. My lord, much before, and not only that, my lord, kindly see. And thereafter, my lord, when the case is initiated against the unauthorized encroachment, they have managed this, my lord, receipt by, my lord, the by the, my lord, help of an, my lord, influential person from the Jila Parishad.
So
And
the receipt is issued by the Jila Parishad.
receipt is issued by the Jila Parishad.
So
My lord, when it is issued, my lord, that is much later than the case is initiated.
so who can challenge the receipt? The Jila Parishad.
My lord,
They have issued it, sir. Why are you?
permitted to interfere.
Yes, yes.
File an application for consideration. SDU will consider and see all the facts and figures. After that, he pass an order according to the provision of law.
This
Now,
type
it
of,
will be-
if this type of
cannot be
petitions
survived,
are
my
being
lord.
entertained, my lord.
My lord, kindly see
My lord,
the pre-
then my lord, the entire,
That is the High Court is not,
There is no lawsuit
consider all the matters. You have SDO, there is a provision.
no,
of
no,
law.
consideration,
No, no.
if, he has to show his legal right,
Has to prima facie establish that he
Yes.
has a.
Yes.
legal right.
Yes. My lord, I am
Because
a-
the application made prior to the issuance of the receipt.
I am giving the list. My lord, no list deed is there or
It
other.
has not been granted.
Then my lord,
The money
Yeah.
has been deposited.
money has been deposited. So my lord, this case, my lord, will be considered by the SDO. That is the fittest person. My lord, High Court is.
My
not-
lord, now SDO,
No,
I do not know, my lord, whether SDO has an power to, my lord, say another government
my
body, my lord, to,
Yes,
my lord,
Yes,
SDO has the power.
I do not.
they
know.
will kindly see.
Jila
kindly
Parishad
see
lordship
the-
under the-
my lord, kindly see the act.
দাঁড়াও না, একটু আমাদের বলতে দেবেন না, তোমরাই বলবে। My lord, SDO has the power. There is any.
Now everyone will come and say, remove this thing from my house, in front of my house, I'll enjoy the entire thing.
Consider, he will consider all the facts.
And though the fact is this, my lord, a 10 feet road is there, my lord, through which he is
No,
having
no.
his ingress and egress.
My lord, even if 10 feet is
Now he
open,
wants the entire
my lord,
thing to
if
be open.
Suppose, my lord, my frontage is 50 feet, and out of that, 10 feet is open. And my lord, whether
Is it?
whether the premises holder can insist upon the court to, my lord, remove the entire structure from the 50 feet. My lord, various judgment and, my lord.
Lordship, if
pronounced-
My lord, there is no such judgment.
Yes, my lord.
There is no such
My
judgment.
lord,
He is
I
having
will
his
show, my lord, I will
rights,
show.
my lord, he has to
I
go
will-
before the
I-
civil
I
court.
will show.
Lordship,
before
kindly
your lordship.
consider, Lordship,
I
if their prayer is for removal,
Removal.
then Lordship, they have Lordship no relief before this honorable High Court. If their prayer is Lordship for ingress and
It's
ingress,
not a
that is
private
Lordship
land,
an
it's a
easement
government
right.
land.
That is to be
No,
Lordship
yes.
adjudicated by the learned civil court, Lordship.
No, my lord.
And my lord, kindly see.
Because under the Act, Lordship, the definition of section 2(6), Lordship, the unauthorized occupants. I am not unauthorized because I have, Lordship, the due process of law. I have applied before the, and Lordship, as the writ petitioner, Lordship, told that the receipt
You
has
have
been
applied
issued
for
after,
regularization. You have
after
applied for
I-
regularization
yes,
of
I
your
filed,
occupation.
but I filed the application prior to, Lordship, the filing of the writ application as the
Show
dispute
me
is created.
When they have filed, my lord, when they have.
That I can show, Lordship.
When they have
Show me
filed.
when you filed your application.
These
When
are
they
the
have filed.
stalls, my lord, which have been, my lord,
And
my lord,
Lordship,
bought
what
up by the
happened,
Jila Parishad, on his Jila Parishad lands. Now he wants to, my lord, remove those stalls. In front of his house, there are
Not,
stalls,
Lordship,
remove.
not entirely on the
When they have made a prayer before the Jila Parishad, my lord, they have to show before your lordship. And my lord, after initiating.
That is
the
a disputed question of facts.
After my lord initiating this case, my lord, they have approached before the Jila Parishad.
Can you
For-
come back with the document showing that you have applied before the Jila Parishad for grant of?
Try, Lordship. Secondly, Lordship, what happened, Lordship? Initial Lordship, primary Lordship, I have submitted before the Lordship that
Have
the
you annexed the
entire,
document,
entire Lordship shop room is not over the Lordship Jila Parishad land.
Document.
Yes, yes.
These
The,
applications,
Application
my lord,
for
I could not.
Where is that application?
My lord,
All
how
the
he is
while on-
concerned about applications, I do not
Already
know.
they have
My lord,
managed, my lord,
he's-
see,
because this is for regularization of the.
My lord, there is
unauthorized
no question of regulation there, my lord.
They are.
My lord, there are,
possession.
there are shop rooms. My lord, persons have been, my lord, asked to have their, my lord, shop rooms, my lord, to have their, my lord, livelihood from those stalls, my lord. So they approach, my lord, we have given the lease of those shop rooms, my lord. Though, my lord, the DM
have
is the
not
authority.
given that
My lord, we have taken that amount, we have received the amount, my lord, the DM will be, my lord, settling the lease to them, my lord.
So the private respondents say that they have filed an application.
Yes,
They
my
have
lord,
been
that
occupying earlier.
earlier.
It was
Earlier,
unauthorized.
because from the
Now they regularize their occupation.
from their retail,
Filing for lease.
but
Provision
the
is there.
structure my lord, is on the land of the Jila Parishad. My lord, that is, there is no dispute
No
about it.
dispute. That is
As well as lordship, part of the lordship construction is over their lordship, over their property.
The private respondents say that they have filed an application for regularization of their possession. I would like to see.
I have
My lord.
taken some instruction, lordship, kindly consider lordship there from their writ application. I am drawing your lordship attention. The father of the writ petitioner lordship purchased the property in the year 1986.
All that is
It,
immaterial.
on
That
that
is not-
time, lordship, it was the lordship water body. And the conversion which was obtained lordship 22nd of December
All that is
2022.
irrelevant. All that
So
is
lordship,
irrelevant.
what is their prayer lordship? They are facing difficulties in ingress and egress.
My
That
lord,
is
there
not
is
true.
road, my lord. There
That is not true. That they are
Yes.
not using the said land. So lordship,
There is
my occupation is
ample
lordship much
passage,
more
road, my lord, in front of his house.
I am also
with their knowledge lordship. It is portion of the.
You have applied for
situated
lease.
over their land.
You have applied for lease on those stalls.
how he will
Yes.
that this portion
Can you
Now he
conduct
will
all
get
the
it
documents
reopened
showing
and
that-
he will
I
get
cannot
his
take
access there.
instruction from my client whether they have the copy of the application. Petitioner cannot seek any order to create easement right to enter.
Well, this is
one portion
purely
of
civil.
the Land. So this is not the law. And will kindly see the prayer B. What he stated. This land, will kindly prayer B, reading the nature of mandamus commanding respondent such and such. Petitioner premises, even if belongs to the public premises, particularly which is used by the petitioner as their immigration address, and it will be used by the intending customer of the business, which will be opened after removal.
Yes.
This is the prayer.
This is the case.
My lord, the petitioner's, my lord, son is unemployed you.
So
And my lord, they
So,
will erect their,
Please
my lord,
read the side address.
kindly see the interest, my lord.
and
Their
before-
prayer is lordship future
I'm
aspect.
sorry,
Yes.
repetition has to be dismissed.
My lord, kindly do that.
Okay.
And the definition lordship unauthorized
By the other way, he is trying to, my lord, get his benefit.
benefits. It is lordship private dispute.
If you are,
No, there is no private dispute
Yes,
at
you have
all.
written in your writ petition.
if you are asking for your easement right, you have a different
My
forum for it.
No, I have no, my lord, I have no
Law-
demand for easement right.
Your
Only, my
complaint is
lord,
encroachment.
only
There
my
is no
lord,
encroachment.
only my lord encroachment.
There is no encroachment as the owner of
My
the
lord,
land says.
Whether this, my
Who
lord,
can
whether,
say encroachment? The owner of the land.
whether this particular, my lord, the affidavit, my lord, the report of the affidavit will prove that it is, my lord, they have leased out the property.
So, my lord, how he is, my lord, affected?
My lord, it is government property.
Yes.
If my lord leased it out,
It's between
my lord,
the
there will be
government
the
and the private
yes,
there will be
respondents.
the deed, lease deed. My lord, where is the lease
My lord,
deed?
why we will
There
bypass
is
those
no
things
bar-
to him, my lord, who is he in the poverty?
My lord,
I
how,
repeat, it
There
is
is
not
no
their
lordship.
case that they have leased it out.
Yes.
They say they have taken the
Yes.
amount, the money, they will execute a
no,
lease.
when they have,
And
my
the
lord,
intent-
deposited the money, when
And
they
the
have.
intention, my lord, is
My lord,
very clear from his writ
I have
petition.
emphasized,
What
my
is
lord,
trying-
when they have deposited
That
the
will come
money,
later.
after a
I'm
long, my
sorry,
lord,
I'm sorry.
my lord, kindly you direct to the sub-divisional officer,
Oh.
that is, my lord,
Nothing, not necessary,
Ekdom.
not necessary at all. Report in the form of affidavit submitted on behalf of the Jila Parishad is taken on record. Paragraph for learned counsels for the parties. Paragraph. The
Appeal, Supreme Court.
এছাড়া কিছু করার নেই।
petitioners complain
গভর্নমেন্টের ট্রান্সফরমার
that the private respondents
আমি
have raised unauthorized.
এটা না
প্রপার্টিটা গভর্নমেন্ট
এটা গভর্নমেন্টের নয়
এই-
সুট ফাইল করতে
I'll dictate if you have completed
sorry,
your
I'm
submissions. কি বললাম? Construction by encroaching upon government land adjoining their property. The petitioners pray for removal of such encroachment. Paragraph. Per contra, comma, it is submitted on behalf of the Jila Parishad and is also the admitted position that the land in question belongs to the Jila Parishad. Stop. Learned counsel for the Jila Parishad submits that the Jila Parishad intends to execute deeds of lease in favor of the private respondents in respect of the said land, for which the private respondents have deposited the requisite fees. Stop. The deeds of lease are yet to be executed. Paragraph. Learned counsel for the petitioners submits that the construction made by the private respondents has blocked his right of easement through the government land, and also, requisite fees for grant of lease was paid during pendency of the writ petition. Paragraph. It is not in dispute that the land in question belongs to the Jila Parishad, who intends to execute deeds of lease in respect of the same in favor of the private respondents. Stop. In view of such intention of the Jila Parishad, it is immaterial as to when the requisite fees for execution of the deeds were deposited by the private respondents. The proposal of the Jila Parishad and the private respondents cannot be brushed aside only on such ground. Stop. Since the Jila Parishad, being the owner of the land in question, seeks to transfer the same in favor of the private respondents by virtue of deeds of lease, it cannot be said that the private respondents have made illegal encroachment upon government land. Paragraph. In view of the above, this court is inclined to hold that the writ petition is devoid of any merit, and the petitioners have no locus standi to challenge the status of the private respondents in respect of the land belonging to the Jila Parishad, more so, when the Jila Parishad itself has decided to transfer the same in favor of the private respondents. Paragraph. Accordingly, the writ petition being dealt with such and such is dismissed. There shall, however, be no orders to cause such and certified.
Kindly observe,
So, affidavit.
kindly observe, my lord, paragraph 8 of the writ petition, wherein he states, my lord, that for his personal, my lord, use and for running his business, my lord, he wants that land to be, my lord, the area to be free.
Not necessarily. That's a separate cause of action altogether.
My lord, if my lord has said, my lord, the entire thing has been done by the Jila Parishad, but his locus standi, so far this point is concerned, my lord, it's, my lord,
Paragraph 8.
in paragraph 8, my lord. He himself stated, my lord, that, my lord, for his personal, his use, my lord, he wants to free out the, my lord, entire land for running his business.
Yes.
Paragraph B of the page 13 is the prayer, wherein he has stated, my lord, if it belongs to public premises, particularly which is used by the petitioners as their ingress and egress, and it will be used by the intending customers of the business.
Easement. I have stated about the easement right.
My lord, kindly clarify.
Easement right বলেছি দেখুন শুরুর দিকে contention of the petitioner কি বলেছি জায়গাটা শুরুর দিকে, it is contended on behalf of the petitioner, এখানে petitioner এর submission. ওখানে add করব. Learned counsel has further submitted that the said portion of the government land is used by him by the petitioners for their egress and ingress, and also where is that stated? The customers
My lord, paragraph, page 13 of the prayer, my lord.
page?
13 prayer B.
रिप्रेजेंटेशन है लास्ट पैराग्राफ है बोले
Kindly see, respondents particularly responded to remove the unauthorized
And-
encroachment.
And for the intending customers of the business which the petitioners intend to start.
Deeply approach.
great
My lord.
Next.
My lord, I am for the petitioner.
my lord, I am
My lord, on last
I
three
have filed
occasion,
I have filed an application for intervention.
my lord,
Have
on,
you served?
Yes, I have served.
my lord, on last three occasion, your lordship directed the state respondent to serve a copy of the report, my lord.
We have to deal with the intervention application first.
Lord, I am the adjoining plot holder. Where blood my learned friends are blood seeking demarcation. And there is a issue of blood encroachment also, for which blood I filed a suit and the suit is pending for adjudication. And I also blood have taken the point of maintainability of the repetition. Because of the reason blood, there are some factual background.
Have to first be added and
Look,
then you can take this
So
point.
these are my points blood which I have blood. I'm an adjoining plot
Is
holder.
it a copy of the application? Intervention application?
his place.
my lord
You are supporting his case.
My lord, at the
Well, I'm lucky enough.
I have taken the point of maintainability. It is the dispute between the private parties and the petitioner.
And we have been intentionally left out. Lord, we have not been made parties in the writ petition intentional. In every document, Lord, our names are appearing, but despite that, Lord, they have not.
What is the prayer in the repetition?
Lord,
For demarcation of the acquired land.
Are you ready for the hearing today of
Yes.
the application? So I'll deal
Yes,
with
yes.
it. Very good. Do you have any objection if the?
Yes, my
intervention
lord,
is
I have
added?
objection. If your lordship kindly straightway come,
Let you place his case first. Yes.
Lord, your Lordship would. So far, Lord, the writ petition is concerned, Lord, that your Lordship would kindly take, Lord, the prayer and. No, I'm going because the tag numbers I'm Lord mentioned. Prayer B at page 9 of the writ application.
Yes.
And now your Lordship would kindly take. Now your Lordship would kindly take, Lord, paragraph 4
Four of the repetition.
of the writ petition. Then I'll Lord make my submission.
Yes.
4, 5, 6, 4.
Now, Lord, this is that there is a dispute with respondent number 7 to 12 as they are claiming that they are owners in LR Dag number 1943, which was adjacent to the petitioner's land. It is well known to them that the said Dag number 1943 was acquired by the government India in 1964. Now, Lord, so far, now they are trying to take possession of the land of the companies by any means. On that, on the other hand, the petitioner is in possession of the subject suit since suit land since purchased without any obstruction. Now, the next paragraph that the respondent number 7 to 12 are not challenging the title of the petitioner's company. Lord, I do challenge, Lord. I have also, I have a challenge. But they forcefully obstructed the petitioner to make the boundary wall with a reason that they do not find their land at LR Dag number 1943, now, which is contrary. As they want to take possession of the petitioner's land. For the above reason, the petitioner's company decided to make boundary wall. Lord, there is no boundary wall. On the other hand, Lord, we have made a boundary wall and there is some encroachment on their part. And now, your Lordship would kindly turn to paragraph 6, Lord. That it is notified in the notification number 75/1981 that the land of the respondent number 7 to 12 part of RS and LR Dag number 1943 has been acquired by the state government for Belghoria Expressway and irrigation purpose. But it is surprisingly noted that somehow the land which was acquired by the government of Belghoria Expressway that was recorded stroke mutated in the name of the respondent number 7 to 12, not while my names is also there. But the existence of the land in RS and LR Dag number 1943 is not there. And the respondent number 7 to 12 are trying to take possession of the petitioner's land in Dag number 1939 and 194. This is another plot number. But I have my locus in Dag number 1943 as well as blood in 1939. That he,
1939.
yes, blood. And their case is that the land is not physically blood present. I say their property has been acquired and it has been taken possession by the blood state. Now there is no property left in their account. So question of demarcation does not arise. On the contrary, it is my property which I am in possession and they are trying to encroach upon me through this writ petition also. And that prompted me to file a suit. So I am a very much necessary party because of the reason I have my right in the property and my names are recorded in the records of right. So blood intentionally, though they have added blood, impleted blood respondent number 7 to 12 as a party respondent, but intentionally left us. So these are my respectful submission.
Now, who is appealing for 7 to 12? Yes.
My submission is also not,
Cause of
hopefully
the-
they will not blood also oppose to our application.
Yes, you are supporting the intervener?
If your lordship kindly come to page 9 of the addition of party application.
Page 9.
Page 9, paragraph 1. My lord, who are they? They are in the middle portion, my lord. In the instant application, though all the applicants mentioned above are owners and possessors of plot number 1936 and 1937. My lord, in the writ petition, there is no claim of two plots number which has been, they are the owners. My lord, I have the objection, my lord, 1939 and 1942. My lord, they are the owners who they are the petitioner are no way connected with the manner writ petition also. So the next line to pado. Thereafter, your lordship kindly come to page 26 once. Page 26 of
Give me a minute. How many applicants are there, interveners?
Lord, there are Lord as many as
15.
yes. Thereafter, your lordship kindly come to page 26. Your lordship, what? My lord, Muja map. Page 26. Lord, they were no way connected with the land of the petitioner. There is a manipulation. That's why I will say also.
Petitioner's land is?
Petitioner's land is 1939, 1942.
So they are claiming 1936 and 1937.
Right, man. As well as blood 1939, 1942 and 1943. Well, where they are ownership.
Stated. In your application?
In application, Lord, your lordship would kindly take blood. Your lordship would kindly take blood the line which my learned friend is has referred blood in paragraph 1.
Yes.
Though all the applicant mentioned above owners and possessor of plot number 1939, 1937 adjacent land of the petitioner who is claiming portion of land situated at Elarna.
The
Lord,
petitioner is.
Lord, I'll
claiming.
just say, they are saying that they are the owners and owners of 1939 and 1942. But there is no 1939 and 1942 because most of the part has been acquired by the state. Lord, I need to refer to the Mojo map also.
But how are
Now,
you
now
connected?
I'll just come. Now, Lord, what they are claiming is they are claiming portion in my land which is situated at 1936 and 1937. No, my lord, that is not the case in the writ petition. Sorry.
There is no prayer.
No, my lord, Your lordship,
Where are they claiming portions of 1937 and 1936?
now, my lord, in 19, your lord,
You are claiming 1936,
I have a
1937.
I have a right in lord 1939 and 1942. Your lordship would kindly turn, lord.
That's stated in your application.
Your lordship would kindly take paragraph 2 for a moment, lord.
Yes.
Your applicant begs to submit the petitioner Chandan Kumar Mandal has not come before this honorable court with clean hands and deliberately suppressed, concealed some relevant material fact in the petition itself in order to obtain favorable order from the honorable court of the petitioner does not possess more than 0.5 decimal of land in plot number 1939 and 1942.
How are you
I'll just come. And all the lands have already been acquired by the state government for construction of highway, and the writ petitioner without impleading the necessary parties who have actual right over the land situated in plot number 1939 and 1942 to the sole attempt is to encroach the adjacent land of the applicants who are in possession of their land, which is barred and bounded.
Even if he's
I am-
encroaching the adjacent lands,
No,
it is not your land.
it is my land.
You have said adjacent land of the applicants, not the
Now,
applicants.
Lord, your lordship would kindly come to paragraph. That the applicants enclosed here with the settlement Khotians of plot number 1939 of Mauja, Sultanpur block, Barakpur, such and such, as was published on 11/2/2023, which shows that the alleged DAG number 1939 contains LR Khotian being Khotian number 14823232927 and 2974. But all owners of those Khotians are not impleaded in this writ petition purposefully to achieve some favorable order from the honorable court. Similarly, plot number 1943 appertains to Khotian number 191410, 5364, 5365, 5366. But all the owners of the aforesaid Khotians, we are also owners of that Khotians, are not impleaded as a party, though they are very necessary party to the writ petition. And I'm
My lord, it will be clear if your lordship wants, my lord, to come to page 26 once.
now, my lord, your lord, my lord, paragraph 11 is also my lord developed.
Yes.
Now, Lord, kindly take, Lord, and one MS, Lord, he has sold out the property, excess land in plot number 1942, which issues are required to be, Lord, it's a civil dispute, that is what Lord I have said. I have got twofold submission. One, that I have a right title in respect of some plots of land which are involved in this writ petition. One. The second is,
Please show me that you have right title and interest in some plots of land.
Lord, I need to produce the deeds, Lord, and the Lord records of right. Since Lord, this is an
In
application.
the pleading,
Now-
my lord, he has not, my lord, stated
Now, Lord,
anything.
the another point, which is very important, they are not in actual possession of the land. Lord, I'll
Are
just,
you concerned, sir?
no, Lord, that
Because you are trying to be added as a party.
Lord, yes, because
So
of the,
how are you a necessary and proper party? I do
I
not
am a,
understand.
then Lord, I am a necessary party because of the reason in this writ petition, my right in respect of the possession and in respect of my ownership of the property will be adjudicated behind my back. Because of the reason, if your lordship passes an order, Lord, if there succeeds in getting an order for demarcation of the land which has been acquired by the state of West Bengal for the purpose of that highway, ultimately my property will be given to him because there is no existence of that particular two plots which my learned friends are referring. But there is no physical
For the
existence.
state to say. This
Lord,
is for the state to assess.
Then your lord, ultimately,
Because you have claimed right over plot numbers 1936 and
I'll
1937.
just show your lordship, Lord, the Moja maps, Lord. I could not annex since, Lord, it was not readily available with me at that point of time. The Moja map,
There's no everment in the application that.
How they
you
are
have
affected.
Any right over 1939 or 1942. And the petitioner doesn't claim the entire plot. Petitioner says 22.31 decimals in 1939 and 25 decimals in
Grateful,
1942.
my lord.
my lord,
Maybe there are other owners of the remaining part.
but
They
your
are not
lordship,
concerned.
we lordship would kindly appreciate one more aspect. Now, who are these respondent number 7 to 11? 7 to 12. They are getting the property. The way, Lord, they have, Lord, succeeded the property. We have also succeeded the property. We are relatives. And there are some
How do you substantiate?
your lordship would kindly
Because
take,
the
Lord,
petitioner says that their names have been recorded.
my lord.
They say wrongly recorded.
Now, Lord, another attempt, Lord, paragraph 9.
If you
Lord,
want to come back with other documents, you can.
Lord, I will,
But with
I
the
shall,
present
Lord.
documents, I do not find anything because whatever you say, the state can say that. It's not your interest that is being affected.
Lord, I will.
The state can say that the land doesn't exist.
Then, Lord, I need to rely on, Lord, the Moja map, which I have relied on in my pleadings. I need to
Your
annex
title, your interest in the land or any portion of the land.
in those particular two plots, Lord, 1939 and 1940.
They are the subject matter.
Lord, I will come back
The
with
submission that you have made,
Lord,
it is for the
oblige,
state
Lord.
to make.
You'll oblige, Lord.
If
Then,
you
Lord,
say that the land doesn't exist, the state can say that. If you say that it is not acquired, the state can say that. It's not for you.
it is acquired, Lord, because there are notifications. Lord. Even our
My lord,
portion has
we are
also been
also
acquired.
admitting it is acquired, some portion of the land.
The acquired land, nothing else.
He is asking for the demarcation of the
the
left out
acquired
land.
Yes, demarcation
Left
for
out.
acquired land.
Cannot ask for left out land demarcation.
Private
That's
property, I
land.
cannot, my lord.
Is not the
Private
prayer.
property, There's no provision for the state.
No, Lord, your lordship would
State can
kindly,
demarcate only the acquired portion.
And where is the problem of the, my lord, intending?
your lordship would
Added
kindly take
respondent.
paragraph 9 for a moment, Lord, if recall.
My lord, if your lordship, my lord, kindly come to page 26 once.
Please come to the prayer portion. To demarcate the acquired land.
Yes, my lord.
So the state cannot add.
Lord,
their
obviously,
state demarcate. Yes,
it's
not
state's
beyond that.
prerogative, but whether they will
Not beyond
demarcate,
that.
not
And
mine,
that's
but
the law.
but my,
If taking possession, the state has to demarcate. This has not been done in this case. That's the law. The
Lord,
law
I was
says.
not, Lord, present since inception of the proceedings. The moment I came to know, Lord, about the proceedings, Lord, and there was some attempt to, Lord, remove my boundary wall. So that prompted me to come before your lordship.
That's
Your
a
lordship
private
your lordship would kindly allow me, Lord, to make a supplementary affidavit specifically dealing with the query of your lordships that how I am interested in respect of the two properties.
My lord,
Lord,
in
I'll
the
come back
application, my
within a
lord,
week.
they do not say anything,
a
my
week,
lord.
Lord,
Now
with
they are
supporting
taking time, my
documents.
lord, for this.
What is the difficulty in the state demarcating the acquired
No
portion of the land?
difficulty, my lord, but there is the question of the maintainability. It is the dispute between the parties, my lord. So, respondent, their allegation is this in the writ petition. The respondent number 7 and 7 to 12 trying to grab the land of the petitioner.
Of the state, not the petition.
No,
The
my-
acquired land.
No, my lord. That
They
is
are
not
raising
correct
construction
statement.
on the acquired
No,
land.
no,
That is
no,
what
no,
is
no, no,
Yes,
no,
ma'am.
no, no. Your lordship kindly turn to paragraph 7.
And they are resisting the petitioner from constructing.
We
the
are not,
Boundary wall.
we are not resisting, my lord. The private respondent is resisting.
Yes.
Even if
So
we
how
ignore
the-
that part, the primary prayer is for demarcation of the acquired portion of the land. So what is the difficulty?
We have no difficulty.
Why don't you demarcate the acquired portion?
We are ready to demarcate,
My
my lord, but it is the question of the.
If the
maintenance.
state,
How
my
they
lord,
have
demand,
with the state
if that
respondent.
state, my lord,
How they have agreed with the state respondent.
my lord, if the state,
Respondents have not, my lord, there.
You have acquired some portion of the plots.
That is correct.
So unless there is a demarcation, the other portions cannot be.
grateful, my lord.
It appears from the, my lord, the application of my learned friend. It has been demarcated twice.
So please come back with the report in that case.
I have come with the report.
The demarcation report.
It is
So that the plot was demarcated twice.
Demarcation
At
for the
least
volunteer.
once.
It is volunteer.
In the report, there is
You
no
have
question
the
of,
demarcation report there.
no, my lord.
No, demarcation is not there, but it is, my lord, reported. The land has
My lord,
been
the
acquired.
dispute will be, my lord.
Purchaser after purchase.
No, let us not deal with the petitioner's case at all. Why don't you demarcate the acquired portion of it?
Difficult, my lord.
That is the only prayer, in fact, of the petitioner here.
We shall only
Yes,
demarcate the acquired
because-
portion, but
Yes.
in the repetition, my lord, they have intentionally, my lord, your lordship kindly come to page 250.
Page?
250 of the. There and is the notification. The plot number 1943 is, my lord. There is no, it is, my lord, the build up with the
1942, 1943.
43 is not there. It
Yes,
is-
yes.
it is marked in black.
Here it is not marked
আরে
as black.
দর্শক এটা দিয়ে দেখেন কালো একদম কালো দিয়ে কেটে দিয়েছে
It's there 1943.
Yes.
Copy something as, why have you
What
marked
is
it black?
this?
No, my lord, it has
What is
been
this?
highlighted, my lord, that
No, no, I don't.
Xerox, my lord.
No, no, you cancelled it.
It was highlighted, my lord. Kindly
Not
see this.
highlighted, ওনাকে দেখান একটু। No, no, it's there in this court's brief also. 1943 is there. Portion of both the plots. Portions of both the plots has been added.
Yes, but in your lordship's responsibility, but in the already it is not.
It was demarcated twice, blood.
Where
Since
is
I'm
the
not,
report? I want to
since,
see the
since
report.
I have blood some documents, blood, since I'm unable to blood represent my case properly at this stage, blood. So
The state will come back with a supplementary report showing demarcation. If it has been
If
demarcated.
it has already been done, if it is already been.
Yes, the acquired portion has to be demarcated in accordance with law. They could come back with the report, they say it has been done. Let the state come back.
My lord, with regard to the addition of party, that should be dismissed, my lord.
I'm not.
Because,
because
my lord, they have not pleaded, they have not annexed.
so that I can come and file a supplementary affidavit, what has fallen from your lordship? Satisfying your lordship that I
My lord,
have right
My lord,
title.
once your lordship kindly come to page 26 once for my satisfaction
26 of,
of the addition of
That is
party.
the Moja map, lord. No, no,
It
Moja.
will be very clear from that.
yes.
My lord, your lordship kindly see at the left hand side, 1943. It is Joseph.
Just,
My lord, it will be, my lord, clear, my lord.
just
Kindly
below
see
M.
my copy. My lord, at the left hand side, 3 plots are there,
1940, yes.
which is petitioner's land. Thereafter, another plot, which is not the petitioner, which is not to the added respondent. But thereafter, the plot which has been marked, they are claiming their ownership. My lord, which is, my lord, far away from the land of the petitioner. Kindly see.
1942 is the adjacent of 1943.
And you are not claiming in 1942 or 43. I have clear.
Right, my lord.
We are claiming lot 1936 and 19, which is just right side. of
Kindly
the-
see,
Right
I
side.
have marked.
Can show that. The
Just
map
right
doesn't
side,
show
lord.
that.
Your lordship has seen, lord. Which is connected.
আমাদের এই তিনটে, তারপরে এটা
No, not
ফাঁকা,
at all.
তারপরে এটা।
193536 is away from the.
Yes,
plot
my
in
lord.
question.
39 is just adjacent and then 1936 is blood again adjacent.
No, no,
The
no.
L shape,
These are not adjacent.
just below blood 19.
There is something else in between, some other plot.
My lord, red marking I have been.
I will just blood mark it and blood your lordship. I'll just give it to your lordship blood. These are the blood 2 plots blood. This one and this one, which is adjacent to 1942.
Please see this, it's not.
But
adjacent.
I just
Not adjacent. There are other plots in between.
Yes, এটা আমার।
এটা কি করবে? 39 এটা 36 এটা
Lord, for this reason, my lord, that
43 and
application.
39 is 43 and 39 is adjacent and 36 connects blood 39.
39 is not 1936 or 198, it's only 39. 39, 40, 41 are separate,
Yes, ma'am.
L shape.
Yes, that is what I'm saying.
39 is not 1939, but 1939 is different.
But if this portion,
That is not 1939, that is only 39. Beside that, you see, you'll find 40 and 41.
that I've seen on the
That
left side.
Yes, that is only
Yeah.
39, 40 and 41, not
42 and
19.
42 and 43 is on the extreme left.
So that is 1942, 1943. These are only in 39, 40, 41.
You should kindly allow me one moment. Lord. No, without the signature.
1936 is away from 1946.
36 and 37 देखिए एक मिनट दाओ दादा माइलर रेट तो दाओ
वो more, you know.
no माइलर
And this is your petition.
no yes
Lord, he has no claim over the land, my lord, which his petitioner is claiming.
so I have Lord some right, otherwise why should I come before your lordship and trouble your lordship?
My lord, if assuming, my lord,
I will
if
just-
demarcation is made, what is the
I will
harm in it,
just
my lord?
give a short affidavit, Lord, satisfying your lordship's query that
Because
how
in-
I have become.
In any event, the report has to come. Please show me the demarcations so that we can solve the issue.
Lord, I'm sorry, Lord, I have troubled your lordship, Lord. I'll come with that instruction that how am I claiming right in respect of that one.
In respect of 1943 and 19.
One page affidavit, Lord, I'll,
199, yes.
Lord, I'll do that.
Heard learned counsels for the
Application
parties
is-
as
Yes,
well
yes,
as
তোমাদের
the
copy
future
দিয়েছি।
learner. Paragraph learned counsel for the intervener seeks to use supplementary affidavit annexing relevant documents. Paragraph learned counsel for the state respondents also seeks to submit a supplementary report
না, আছে তো বটে সুটটা দেখলে তো সুটের কপিটা আমার কাছে নেই সুটে এক্সপ্লেন
demonstrating that the
ওই তো কপি রিফিউজ করে দিল জজ সাহেবের কাছে আছে। ওই যে
acquired
কপি গুলো
portion of the plot has
ওই যে সব বাঁধা আছে।
আমি দেখে
demarcated
অ্যানেক্স করে নিয়ে আমি
by the government.
My lord, I have served, that has been refused, my lord, this, there is the copy, my lord.
So
কপি অফ দি রিট পিটিশন
give him the copy from me. Copy দিয়ে
কবে
read petitioner copy আছে
জানি
paragraph let the matter appear under the same heading
একটা
on
একটা দিয়ে দিন, একটা
5th August.
31st অগস্ট
একটা
Next. So এসছে petition copy গুলো যে ইনকাতে আছে ব্রাঞ্চটাতে আছে
My lord, matter fixed at 12, my lord, matter fixed at 12.
Yes. ওই specially
So no more.
Matters.
44 fixed at 12.
My lord, I yesterday, your lordship kindly recall that I yesterday, my lord, mentioned the application with this matter. My lord. I
Have
mentioned,
you served copies to
my lord, I have
the
served, my lord, on the.
may I
for the
explain?
petitioner.
May I explain what has happened? This is,
And, I wanted to serve on them, my lord, the private respondent.
Yeah, I did as a party.
I'll explain
Yes.
the reason why. This is not the first time that this situation has
This is
arisen.
My application, I will explain the reason.
No, no,
Please kindly
why-
allow me.
Why I have not
Kindly allow
received, I have to explain. You can't explain why I have.
No,
not
no,
received.
my
How can you explain
This
this?
is my application, sir, this is my application.
Yes.
The reason is that this is not the first time this has happened. At 2:30, 3 o'clock in the afternoon, it was sought to be served to me. Knowing very well that this matter has been fixed 1 month earlier, for today specially fixed. If he was so aggrieved and he was so interested, he had all the time to do it. 1 month ago, he had it.
Finally received a copy of the
I can receive it. I have no difficulty with receiving it at all.
Yes. Very innocuous prayer, my lord, very innocuous.
No, it may be, for him, it may be innocuous prayer. I will deal with it. What I am only submitting is, your lordship will certainly accept that application. I will accept it also. There's no difficulty with that. All I am saying is, your lordship will keep that application because it is now time for me to make my submissions. Permit me to make my submissions. Once I am through, your lordship by yourself will decide whether this application needs to be discussed.
Can that be done in accordance with law?
I'm sorry, my lord.
Does the law permit so?
No, my lord, I am only saying that he is not a necessary.
Unless I reject his application, I cannot proceed with the main matter. That's the
That
law.
is exactly what I'm trying to say, your lord.
He has to face his application first. If you are ready with the application, we can deal with it today.
Then in other words, my lord, what I will let him place his application. It has not been, it is not. It is not.
Please serve copies, sir.
My lord, I wanted to, as he explained, I wanted to.
Yes,
My
at
lord, I
2:30 in the
gave- my
evening.
clerk gave a call to them, my lord, but they
You
didn't.
not the others.
Yes, my lord, I have served on the learned advocate for the petitioner, my lord. They have
But
not,
this
they
is
are
an
the principal
application for
defendants.
addition of party. My predecessor in interest was the plaintiff.
The respondents, please serve them a
No doubt.
copy.
I have to
This
serve, but I tried to serve them, my lord. They did not receive the call.
This is a simple ploy to delay and derail the.
No, no, not at all.
I'm making my
I'm-
submission.
I'm not
Simple.
aware.
This is yet another attempt. This is the third attempt that has been made to derail and defraud, my lord. They've attempted it twice
Sorry, but
in the suit court. Here is the third attempt. Let me make,
so my lord,
You're opposing this application.
yes, I am opposing it simply because he is not a necessary and or proper party. For the
then
same
my- then
reason
my
that
lord, also kindly hear me.
for the same reason,
Sir, copy, how can I hear an application? with copy of this application?
I'm trying to, my lord, my lord.
My lord,
Not accepting.
for-
I'm trying to.
Receive it here and now.
yes, yes, I will receive it here and now.
Yes,
Yeah.
please serve here and now. Please serve here and now.
But you didn't.
He's not a necessary and I will deal with it during my submissions.
When can you come back, sir?
My lord,
No, no, Milan, I will deal with it here and now. I will deal with it here and now.
very good, my lord. Very good, my lord.
Can we keep it tomorrow or we will deal with it?
Tomorrow, you'll be here tomorrow?
Yes, he's here. And depending upon what my learned friend submits, I will deal it without any affidavits. I will deal it here and now. Because my submissions will take care of even his admission.
Please come back
application.
tomorrow at 12 o'clock.
Can we keep it at the top now? Because this will take a substantial amount of time. And I will need to convince your lordship
That's
that,
why I said
I'm sorry, Milord.
12 noon tomorrow.
It's only a request, Milord. Can it be a little early?
I have to. Started
No,
by
I
now.
understand. I am not pressing your lordship.
Several other-
I am certainly not pressing your lordship.
And the difficulty is I'll not be here for the next 2 weeks. I have a circuit bench at Jalpaiguri.
I understand, Milord. That is,
So I have to deal with some other matters of state.
no, I understand, Milord. I am not pressing your lordship.
My lord, I'll come back.
I cannot do that. I'm sorry because I have to
See,
deal with other matters also. Several other matters are pending. I have to deal with them also.
Milord, what I'm submitting is let him make his submissions tomorrow. My submissions that I will make tomorrow will deal with the writ petition as well as his application. Because that will be a holistic approach that I will take. I will do that. Because in my submissions,
File make my submission on the application. Thereafter, let him, my lord, make submission.
I'm
on the
only
main-
saying-
On the
I'm
merit of
only-
the case.
I'm only submitting,
Yes, said.
I'm saying the same thing that you are saying. You're saying it in English, I'm saying it in Pushtu. That's all.
All right.
That's the only
Let it
difference.
done, let it done by,
That's
tomorrow
the
at
only-
12 o'clock.
Because when
Please come back at 12 tomorrow.
I will make my submission without
Serve the
affidavits.
copies here and now.
Yes, I will.
Council-
Yes, and I will deal with it. No problem. I will not deal with it on affidavits.
I was trying to conclude it today.
This is exactly what I started off with.
I know, I'm very sorry. He has to travel.
This application has been filed, the writ petition has been,
The virtual mode, sir. Why don't you appear on the virtual mode? I'll allow you. I don't think it will be over by tomorrow.
the way it is going on, that's exactly what I said. There is a repeated attempt to delay and derail.
Learned Council is coming.
Not at all.
State
Not
also
at all.
does. Virtual.
Yes, there is no difficulty with that. Repeatedly, Mr. This habit of, shall we say, shooting from the hope, it has to be stopped. And I will deal with it very vehemently tomorrow. Let him come tomorrow and make his submissions. I will deal with it. Without affidavits, I'll deal.
An application has been CAN 3 of
Termination from
2023 has been
Come to my
filed by
chamber, let's
the
deal with it.
intervener seeking to be added as a party respondent to the writ petition. Paragraph copy of the application is made over to learned counsels for the parties. Copy of the application is made over to learned counsels for the parties in court this day. Paragraph, let the matter appear under the same heading. On Saturday. Tomorrow, that is on 7th August. Marked at 12. July, marked at 12 noon.
The way things are going, I don't see it culminating during my lifetime. It's very unfortunate. Come, issue. I'll deal with it.
Next.
I appear for the KMD in this.
I am for the state. Hey, now. Now.
I can vote in.
One. It's a big application.
ওরা ছিল ভালো। There ছিল petitioner ছিল ওখানে বাইরে। They are waiting for.
Yes.
Petitioner is waiting for my lord. But without.
My lord, I am for the petitioner. My senior is engaged, so he told to take not today.
Yes, ma'am.
On care of the
Right,
petitioner, the matter is that petitioners. And the matter is the matter is on 24th August.
My lord, 15 is also same.
He is also saying, Mr. Deodaran,
No, I'm for the state.
I'm for the KMD.
same date, same order.
Grateful, my lord.
Next, item 16.
I'm for the state.
Lordship, in this matter, the petitioners
My lord, in this matter,
purchased
I'm
the
for the Howrah Zilla Parishad, my lord. I need to take some instructions because I have not yet received any instruction, my lord.
Lordship, in
So-
this matter, petitioners purchased the land from the erstwhile owner. Petitioner developed the land after due conversion and Lordship, the permission from the concerned Jila Parishad. Now subsequently, petitioner received a notice from the concerned Jila Parishad that the land has been acquired. Now Lordship, petitioner appeared in the hearing, produced all documents. Now subsequently, the Eastern Railway also, Lordship, they issued a notice, Lordship, not to, Lordship, continue with the construction. Now, Lordship, this order is under challenge. Now, Lordship, there is a direction to, Lordship, file a report on behalf of the Eastern Railway. Now, Lordship, state government has filed a report to that effect.
Who is
Lordship,
Only my lord.
Lordship, kindly come
appear-
to the report of the state
Appearing for
government.
the railway.
Yes.
My
there
lord,
is a
earlier,
report.
earlier occasion, my lord, direction upon me to file
A report in the form of.
report submit.
affidavit. Where is
Can
the
it
report?
take time to 1 2 weeks? Can you, my lord?
Lordship, because here, also I am objecting to that
Direction
effect.
was 1 month back, sir. Where is your report?
Already a report is ready, I sent to vetted, vetted.
Lordship, I am objecting to that to some extent.
Private respondent?
My lord, I am.
Yes,
private
you want to
respondent.
take instructions as to whether these plots are involved in the public interest litigation. Have you taken instructions?
May I most respectfully submit to your lordship. Sorry to multiply. These two plots, 22-7 and 22-08, 22-07 and 22-08,
Yes.
which is the subject matter of this application, corresponds to old plot number 2195 and 2196. And the same is evident from page 33, the sale deed that they have annexed, paragraph 3. This entire 7 katha, 4 chitak of land has been acquired by the government of India and the gazetification it was published on Gazette
Also, this is on merit, Lordship. Let me submit. This is on merit.
Sought to take instructions as to whether these plots are involved in a public interest litigation pending before the court.
It is indeed.
Where is the document showing that it is pending, sir? Then I cannot deal with the matter at all, isn't it? It is subject matter of a public interest litigation, plots. I cannot deal with the matters.
Lordship, kindly come to the
The
report of
land is
the,
involved, my lord. This land is
Lordship, kind-
involved.
Yes?
Land is involved, the field matter.
Lordship, kindly come to the,
So please show me documents.
Show me documents, kindly, my lord, on field matter, kindly. my
Lordship,
lord.
kindly come to the report of the state government. Lordship,
Necessary. I am not going into merits at all. If the land is involved in the public investigation, I will not take it.
Lordship, yes,
Yes, my lord.
Yes, Mr. Day, are you aware?
Plot number से already लिखा था.
I filed the report, my lord.
This is the application before the SBI bench. Please indicate where these lands are involved.
এখানটা আছে না? এই যে পরের পাতাটা আছে। Pillar plot number.
Mr. Mukherjee, are you aware?
My lord. My lord.
this is absolutely a separate petition. I don't know why they are citing.
My
Because
lord. This WPA 89/2023 are involved in who is the petitioner is appearing.
It's a public investigation. What is the issue there?
My lord, issue is concerning the.
this is a notification, Lordship. This is absolutely a separate, on the separate cause of action. This is not related
No, my
to
lord.
my challenge. Sir, একটু বলতে দিন না, তারপরে complete করুন। This is absolutely a separate cause of action. In this writ petition, I have challenged the order of the Eastern Railway and the Jela Police. Lordship, I am concentrating these 2 points.
This is the present petition.
And my lord will find the plot number 2008.
Yes.
Steeper.
That is on merits. I'll deal with it. On the earlier date, you said that these plots are involved in the public investigation. That was your submission. So how do you? receive that? Where is the document?
পারবো না। ওই acquisition হয়ে যাচ্ছে কি হয়েছে? Yes, it's the acquired land. I'm also saying it's the acquired land.
Matter, my lord. Plot number is the export number 11, 12, 13 is the present petitioner.
What is the issue in this public investigation? Is it the
It's the
same?
filling of a
Same
water body.
Same land, same property. man.
This is filling up a water body.
State party fine, but what's the subject matter?
My lord,
Lordship, kindly come to the prayer. This is a filling up a water body.
The petition,
I'll not take time to while I'm sub already. Take time, can you before?
come back with your report, please, in annex.
Yes,
the petition.
Well, Lordship, I need some interim order because there is a required of interim order.
My property is not my
Lordship,
my time, my lord.
1961. Connecting railway project. The project did not see the ray of light. Subsequently, since the land, even in this case, it is a fact on record that they have taken compensation against land acquisition for plot number 2208 and 2207. Subsequently, since nothing happened, certain things transpired behind the scene, and these plots started changing hands. As in Southeastern Railway.
This is on merit, absolutely.
Southeastern Railway did not take possession of the lands until the petition was filed. And when the petition was filed, all these plots are mutated against Southeastern Railway. These 2 plots in question, measuring about 7 kata 4 feet of land, that is also part of that of the land which was acquired by the government of India in 1961. Now, interestingly, my lord, in this application, from whom the petitioner said to have purchased the land, they have not made him a party or his heirs. And the sale deed is there, page 33, the sale deed is there.
Copyright parties, why, how are they concerned?
No, but this land belongs to Southeastern Railway. That is what has been reiterated by the panchayat, by the railways, and by the state as well.
You are appealing to the private respondent. Yes. So let the railways come back with a report.
Lordship, let me submit something. I need some interim order. I need some interim order. Lordship, kindly come my prayers. Kindly come my prayers of the interim order. Lordship, the authority issued an order. Sir,
Can you produce a copy of the writ petition pending before the
Yes, this is the writ petition pending before the. Yes, two writ petitions are pending. Lordship, this is the writ petition. Previous occasion, I have produced the 2013.
connection with the same plot I want to see.
No, Lordship, this writ petition has been filed where we are not a party and the plots are different. This is the one of the writ petition.
That is not relevant.
That is.
Show me the relevant writ petition.
Now, relevant writ, sir, I have a mamla, Lordship, this is, I cannot, Lordship, I cannot. Now, Lordship, the second writ petition, Lordship, I submitted a demand of justice when the railway authorities stopped my construction when it was about to 90% complete. And Lordship, the Jela Parishad also issued, in spite of issuing the sanction plan, subsequently at the instance of the Eastern Railway, issued the stop work notice. Challenging the same, I submitted a demand of justice. The demand, immediately after getting the demand of justice, the same persons who is the Lordship, the social worker, so-called social worker, filed another writ petition before this Honorable Chief Justice. Now, what is the ground? Ground is, Lordship, this land where I have constructed this building, this is a multi-storied building, it was previously classified as DOBA, water body. Now, Lordship, in this water body, we have constructed the multi-storied building. Now, this filling of the water body is absolutely illegal without conversion. Even the Inland Fisheries Act as well as 4C of the West Bengal Land Forms Act, challenging the same, a writ petition has been filed. Now, Lordship, kindly see this writ petition on prayer.
So this is squarely covered here. The same issue.
No, Lordship, here in this matter, Lordship, my case is the Jela Parishad has issued a stop work notice and Eastern Railway has issued a notice that this allegation is illegal. Now, Lordship, kindly come to the report submitted by the state authorities, the last occasion.
I'm not on merits at all.
The state authorities say this is a one Satak area has been acquired in respect of both the plots. Total area is 5 decimal and 7 decimal.
First, see the copy of the.
Yes, this is the copy.
The writ of the public interest.
Yes, this is the public interest litigation copy. Madam, kindly come to the prayers. This is absolutely illegally filling up the water body.
And you have made your construction on that water body.
Lordship, I annexed the document. There is a conversion. The DLRO
Decided by the court first.
This is the report. This is the conversion order of the state government.
So when that is pending, how can you file this writ petition again?
Writ petition I have filed challenging the notice of the railway authority. Railway authority notice is not under challenge before the public interest litigation.
But it's the same land.
Lordship, if I have illegally filled up the water body, my building will be demolished. That is, I am not in this. Lordship, I am not standing in the way. But here in this case, the Eastern Railway has issued the notice because I have constructed the building on the acquired land. That's why, Lordship, I am just praying for let there be, Lordship, produce the state government's report where it is stated that this is the report of the collector that in 2 plots, only 1 decimal each has been acquired. And even is the worst case, Lordship, I lost. I can release the 1 decimal of land.
So, Mukherjee, I don't think any can be granted to you. This matter will be out of place cyanide. Till it is disposed of by
Lordship,
the.
may I explain? May I explain? Lordship, kindly.
Prayers here.
This is absolutely a filling of the water body.
Allege that your construction is unauthorized.
The unauthorized in respect of that this is the water body.
The same does. In respect of is not relevant at all in this case. The bench is deciding the matter. It is pending before the PIL bench.
PIL bench in respect of that I have illegally filled up the water body and in the water body I have constructed the building. This is the issue in the Lordship, the public interest litigation. Lordship, kindly come my prayers in the present.
I have seen the prayers.
My lord,
Notices.
I have challenged the notices of the railway authorities as well as Jela Parishad.
connected to your construction?
No,
Which is alleged to be illegal.
construction on the ground, that on the acquired land, I have raised the construction, not the filling of the water body.
This is also the same thing.
Lordship,
On the same land.
Lordship, they have, kindly, Lordship, they have, Lordship, Lordship, kindly pass order, let me explain. Lordship, they have issued the notices that I have raised construction in the acquired land. Now, Lordship, this is the notice I have to challenge in any forum. Lordship, kindly, I am asking myself where I shall go to challenge the same.
Nowhere.
Nowhere.
The petition is disposed of by the PIL bench. You have no relief at all.
Listen,
Because
this
the
is
very
absolutely different aspect.
Not at all.
This is the filling of the water body.
Same land, allegation is you have filled up the water body, there's construction. The state says construction is on acquired land.
State
Right?
says, no, Lordship, the filling of the, this is the absolutely filling of the water, only this issue in the public interest litigation.
Same dark number, it is the same land.
Lordship, the dark number is the same, but Lordship, the issue, cause of action is different. That is of the filling of the water body.
Then join issue in before the other court, before the other bench, not here.
No, Lordship,
Okay,
then Lordship, kindly, I am asking me how this shall impugned order notice of the concerned jail position and Eastern Railway, who has stopped my construction as well as selling of the flats, where shall I go?
Your construction needs to be stopped in any case because validity, legality of the construction is pending before the PIL bench. Right?
The validity of filling of the water bodies in the PIL bench.
Is the construction on that land, sir.
Lordship, this is, I have raised the construction.
I don't think I can spend further.
Then
time
Lordship,
on
kindly refer the matter to the PIL because I cannot, Lordship, stay.
this. I can-
Sir, please. Lordship, I cannot stay.
Can I refer the matter to the PIL bench? Can a single bench do that?
Yes, can, because as this, Lordships, as this, both the plots before the PIL bench and before your Lordship,
I will only release the matter. That's it. Or I can stay, make it out of this. That's it.
no, Lordship, kindly then observe, kindly consider my Lordship submission. I mean, Lordship, kindly.
Why are you on merits, sir? I am not on merits at all.
Now, Lordship, kindly,
The ambient
kindly,
matters are same, similar.
kindly observe my submission that unless this bench, I have no other option to challenge both the orders.
Join before the PIL bench because it's the same issue.
Then Lordship, kindly refer the matter to the PIL bench.
I cannot send it, sir. That is beyond judicial authority.
Then Lordship, I am without interim order. I am without interim order.
But you are not entitled because your land in question is in dispute.
Lordship, Lordship, kindly record my submission, Lordship, because I have to, Lordship, because there is no option. Kindly record my submission. And Lordship, kindly also consider the interim order is defeated.
Submitted on behalf of the petitioners that though a public interest litigation is pending in respect of the self-same plots of land. Numbers 2207 and 2208 under the DUINNY, comma, jail number 35, comma, station Shakrai, comma, district Howrah. Corresponding to RS plot numbers 2195 and 2196. Comma, the cause of action therein can be distinguished from the cause of action of the present writ. Paragraph. Comma, the petitioners have sought to challenge the notices Where are these notices? 29th
Yes,
October.
kindly come to my notice. Page 99. South by Southeastern Railway. 99, 100 and Lordship the
October and
Lordship, kindly come 113A, type copy, and 114A, type copy. This is the impugned notice of Howrah Jila Parishad and Eastern Rail.
for the Jila Parishad and railways, I don't think further instruction is necessary because PIL is getting. Right. Howrah Jila Parishad on 22nd December 2022. And Southeastern Railway on 29th October 2022 respectively. Stop. By the said notices. Directed the petitioners to stop construction work on the plots in question on the ground that the plot belongs to the Southeastern Railways. In the public interest litigation, WP bracket 3 number 89 of 2023, comma. It's alleged that the private respondents therein who are the writ petitioners have raised illegal construction by filling up a water body and also by encroaching upon the land of the Southeastern Railway.
8 lines of filling up the water.
In the said public interest litigation has paid for issuance of nature of randomness. Commanding the respondent authorities to stop the illegal and unauthorized construction carried on by the private respondents upon the plots. Private respondents bracketed hearing upon the plots involved in both the this court is in fact told that since The subject matter of the public interest litigation is unauthorized construction raised by the present writ petitioners by filling up water body and by encroaching upon the land belonging to the southeastern rim former. I have to send it out of list.
Well, also kindly consider my submission that these two litigation cause of action is the cause of action is absolutely different, and there is no other forum to challenge this both the impute letters.
Cannot be taken up for consideration till the matter is decided. The public interest litigation is decided on merits. Another thing I let the
Lordship kindly consider that my prayer to refer the matter to the along with the public.
beyond law, sir. I
Lordship
cannot-
kindly record my submission. Lordship kindly record my submission that my prayer is.
Kind of, you can join there. I cannot say- Next. Speaking to the honorable chief justice, you must understand the single.
No, Lordship, because I had unless this.
If I record your prayer, it will indicate that the honorable advocate is not aware, and it cannot be sent to the court.
No, lots of sometimes I have seen that any public matter related to public interest litigation move before the honorable single judge, it is referred to the.
Can withdraw this matter and file there. This court cannot send. There's a difference.
I in my life some instance I have seen. That's.
Sorry.
এই আমাদের রিটার্ন নিয়ে চলছে।
My lord, in item number 17, I beg to appear for the Union of India. I'm led by the learned ASG, my lord. If your lordship kindly accommodates me till Friday, my lord, because the learned ASG wants to move the matter himself and come on Friday.
Beg
And-
to appear for the opinion, my lord. This is that enemy property matter. Kindly seize my lord's last thought. My lord,
Yes, I have.
on 5 occasions, the matter has been heard. My learned senior friend has addressed your lordship on all occasions.
My lord, on the last occasion, it was your lordship's direction, my lord, to file in further instruction in the form of affidavit. I have prepared an affidavit, my lord, but my lord, kindly grant me leave to correct I have written affidavit in opposition. It ought to have been affidavit instruction in the form of affidavit.
That's that case. This
I have, I only
When
this.
you do such corrections after it has been endorsed by the commissioner of affidavit.
And nothing served on us, nothing served upon
That is
us.
the instruction only. Your lordship only directed me to file instruction.
My lord, your lordship may kindly look at it, my lord, what,
I've admitted more or
Yes.
less the case of the petitioner.
yes.
You see that the
Your lord-
property has not been demarcated.
Your lordship directed, no, I want to file them as per your lordship. Your
Plot has not been demarcated.
It's not demarcated. I have, if your lordship allows me, I can place the instruction.
We refer to 8 of the properties which are vested. The only question was, which are those 8 properties?
Yes.
Now, my lord, what I have stated in the instruction also, my lord,
Can you come back tomorrow?
my lord, if your lordship kindly accommodates me on Friday, because the learned ASG wants to move the matter himself.
Come back.
Friday, LRTT তে বলছি। Monday, if it comes, your
The
lordship,
circuit bench admitted.
Lord, on,
2 weeks I have not.
not your lordship, Lord, on Friday, maybe at 2 o'clock. But tomorrow at 2 p.m.
Tomorrow 2 p.m.
ফিরতে পারো?
Tomorrow. Yes. Will you come back tomorrow? Tomorrow's petitioners are due from 2 p.m. First half.
First half, my lord.
Second half, tomorrow.
Today 2 p.m.
Why do you want to eat into group 7 matters?
Well, we are suffering immensely,
I
immense.
understand, that's.
Now,
why
my
I'm
lord,
bringing
the,
up the
the
matter.
persons who have purchased the property, my lord, the flats, they are hounding us.
Let it appear on Friday, that is, you have difficulty on Friday.
Friday, my lord, the first half I have a problem because I've already given word. Otherwise, I would not have, my lord, would not have troubled your
I
lordship
thought
at
in
all.
that case, come back after 2 weeks.
Lordship keeps it on Friday. Uh, maybe the way your lordship fixed the other matter at 12 or something, my lord,
I have no.
fixes it at 1 o'clock. At 1 o'clock, I don't think it'll take more than 15 minutes. If it takes more than 15 minutes, we'll come back later. Acha, in the first matter in the morning, is to be mentioned, or whatever, my lord, for in the
First matter to be mentioned then.
Your lordship kindly fixes at
Whenever
1
we-
PM. I
whenever.
think my learned friend
I
also
have
have no
no
issue.
problem.
At 1
Any
PM.
1 PM,
There is
12:30, keeps it at 12:30. I'll take a chance. 12:30.
12:30, very
Deeply obliged, my lord.
very bad, because it's a very simple, short issue. It's being dragged for no reason at all.
My lord, learned ASD wants to move it himself. That is the
ASD
sole
সাহেব আগে থেকে
issue,
তো
my
ছিলেন
lord.
না। রয়েছে, ASD সাহেব আগে ছিলেন
Mr.
না।
Chatterjee, all well at your end.
No, my lord, it cannot be. And my lord knows it much better than me. Very slow. I don't think if you recover from it, you learn to live with it. Live with it. Yes.
আজকে আর নাম লিখে আজকে কিছু অর্ডার তো হচ্ছে না না
আচ্ছা, অর্ডার তো হবে, তুমি চিন্তা করছো না।
না না হচ্ছে না, হওয়ার দরকার নেই, হওয়ার দরকার নেই, সেটাই বলছি, দরকার কি আছে?
কারণ অর্ডার হোক, তোমারও হবে, আমাদেরও হবে।
না আমার টাইম হলে অর্ডার হবে।
Chatterjee, the slip that you give, there it was stated as only of the professor, right? How?
এই আমার নাম ভুলভাল লিখেছো কেন?
এই জন্য আমি লিখেছিলাম অন্ত ভট্টাচার্য।
That
তো
was
তুমি
the-
আমার চেও না?
My officer was vehemently opposing when I told him that you have made a mistake. He said, no, the slip says only. of the professor."
ছিলেন না?
না, হাতের লেখাটা কার একবার
হাতের লেখাটা একবার দেখে নিলে। তুই চ বাইরে চ,
By consent of
তুই
the
বাইরে, তোর বউকে নিয়ে চ।
By consent of the parties, let the matter appear tomorrow under the same heading. tomorrow.
Friday.
Friday, my lord.
Friday.
Friday. Friday, my lord.
Oh, on Friday. Appear on, that is, Friday is 28th. Let the matter appear under the same heading on 28th July. Marked at 12:30.
12.
Marked at 12:30.
Deeply obliged, my lord.
Grateful, George.
I hope you can conclude that. Twelve noon. 12:01 PM. Noon করবেন না, 12:30 PM. Next.
Lordship, Item 18, I appear with the petitioner, Lordship. Lordship, petitioner wants to withdraw the application, Lordship, not press the application. The written instruction, my lord.
Lord, I am appearing on behalf of two of the private respondents.
Yes.
Learned counsel for the petitioner submits that the petitioner does not intend to proceed with the matter any further. Paragraph of instructions submitted on behalf of the petitioner is taken on record. Paragraph in view of the above, the petition being WPS such is dismissed for non-prosecution. Paragraph, there shall have been orders to cause.
I'm grateful.
Next.
I appear for the petitioner. This is with respect to after the second round of writ petition. May I file my affidavit of service?
Right, my lord. We are appearing for the respondent, KMD.
Yes.
Affidavit of service. Lordship, this is Lordship, the petitioner.
Respondent?
No,
KMD
there
is
are
the only respondent.
the only responsible
Yes, yes.
persons. Lordship, the petitioner participated in a process and Lordship, a plot of land was allotted in favor of the petitioner. But however, my lord, the lease deed could not be executed. In those events, my lord, the petitioner approached this honorable court and filed a writ petition. Lordship, I'll straight away take Lordship to the first order which was passed, which is at page 101. Lordship will get the entire gist of the dispute.
Yes, once again.
page 101, the petitioner felt aggrieved by the inaction on the part of the KMDA in not executing the deed of lease in respect of the plot of land allotted to him even after deposit of the entire premium as well as compliance of all other formalities. The learned advocate appearing for the KMDA fairly submits that because of the procedural snag, the lease could not be executed. However, he has been instructed by the law officer who is personally present in court today that the execution of the lease deed can be made within a month from date. In view of such submission having advanced on behalf of KMDA, this court feels that agony and anguish of the petitioner reflected in the instant writ petition has been sufficiently taken care of. The writ petition is thus disposed of, directing KMDA to execute and register deed of lease within 6 months. However, due to deposit of all amounts, if there be any amount remaining and fulfillment of other forms required for. This was the order. Lordship, thereafter we communicated the order to the respondent authorities. And Lordship, we were given a draft deed of lease to be executed between the parties. Lordship, we had deposited the sum which was required to be deposited. We were called to the office of the respondent authorities for execution of the lease deed. But, my lord, neither in the lease deed nor the respondents in Lordship orally, they did not say how are they going to hand over the plot of land. Lordship, the execution itself, it is only a paper. Lordship, the lease, Lordship knows it's a right of enjoyment. Lease could not be executed because we wanted that, please tell us when you are going to hand over the possession. Lordship, they avoided the issue. Lordship, today, Lordship, I am on the only on the issue that let them give a date when they are going to hand over possession and execute the lease of deed. Lordship, this is only for this limited purpose.
Yes.
But pursuant to the solemn order passed by Honorable Justice Horish Tandon, my lord, several communications were made with the writ petitioners, my lord. Last communication, my lord, our communication dated 15 February 2019. We invite.
Lordship, I ought to, Lordship, before I ought to have mentioned, my lord. After this, Lordship, we had taken out an application for contempt before Justice Tandon, my lord. But, my lord, nevertheless, since so many years have passed, we have filed this writ petition afresh. My lord, that is that application is pending, my lord. The contempt. But, my lord, since, my lord, this is also other causes are required, the handing over of possession, so we have taken out a writ petition. Lordship,
I think you have to first withdraw or
Lordship, we shall.
content and then come back before this court.
Yes, for the last, Lordship, 3 years, His Lordship did not sit singly. We have mentioned that we are ready to withdraw. We have asked for the
That part and come back. I cannot.
Lordship, His Lordship is not.
Subject matter of the contempt application also.
That is a fact.
But contempt, my lord, the jurisdiction is completely different, my lord.
It's the
It
same
is in the.
Whatever, yes, my lord, whatever passed by Honorable Justice Horish Tandon, my lord.
But, my lord, His Lordship is not going to sit singly, Lordship, anytime soon, my lord. Lordship, we for the last 4 years we have mentioned. And we wanted to withdraw, Lordship, but.
It will take a minute, isn't it? So please request it.
But
Unless you withdraw that at two simultaneous proceedings cannot continue together.
Lordship records my undertaking that I shall withdraw. Once His Lordship sits, I shall immediately withdraw. But His Lordship is not going to sit, my lord. For the last 4 years, there are not a single day His Lordship sat.
Make a comment on this. Try mentioning, come back.
We have
Both
tried,
the
my
matters
lord.
cannot go on together. I'm sorry.
But then keeps it next week, Lordship.
I may be sounding very technical, but then I cannot.
Lordship, I completely understand. Lordship keeps it next week. I shall try to.
Do you agree to go before some other bench? I have a circuit bench for 2 weeks.
Sorry, ma'am.
I have a circuit bench for 2 weeks. I'll not be here. So
Lordship, after the circuit bench, after Lordship returns from the circuits, ma'am.
appears to be a short matter, but please come back.
Lordship.
Affidavit of service. Paragraph. I'm just adjourning the matter. On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the heading on 17th August.
August.
17th August.
First up. Next.
নাম লেখার কাগজ নেই।
On behalf of the petitioner, Lordship need not take up the blood. My learned senior friends have used an exception. I used a report that I have to use an exception to that. When my exception is almost ready, I just need to go through it once. Gives me a lot of weeks time. I'll finish that the weekend because I was not in a position to do anything. My lord, gives me this weekend. I'll do it. Takes it up just after my lord comes back from the.
There's an interim order.
Yes, till
You don't
31st.
fix it. You have not made your submission.
That's automatic.
Not at all.
That grateful to your lordship for reminding me that it's still the 31st.
Why did I actually? I shouldn't have.
He was prompting, but it came from my lord.
The learned counsel for the petitioner seeks extension of time to use the exception as sought. Paragraph, let the matter appear under the same heading on 22nd August.
No problem.
Paragraph, the interim order granted earlier is extended till 31st August or until further orders, comma, whichever is earlier.
Grateful to us. Not extremely.
DML instruction page. Time.
That I need to appear on the state.
Well, I am for the respondent number 10 and 11.
Yes.
My lord, petitioners are the owner, my lord, with respect of the land in question. This is at Borjora. My lord, the Durgapur Project Limited, my lord, started, my lord, open mines there. And my lord, they are, my lord, gathering, my lord, the soil, my lord, on our land. And also the mine drainage water is going on through our land.
Durgapur Project Limited
But I am appearing.
and the West Bengal Mining Development Trading. Mr. Shah
Nine?
generally
Mr.
appears.
Shah usually appears.
Mr. Shah usually appears. Have you served?
Yes. Sanjay, sir.
Sanjay. My lord, I have served upon all.
The last Secretary Department of Power, you are representing.
Lordship.
The Mineral Development.
I don't know.
My lord,
The past representation made on in the year 2015.
Give me a minute, please. Have you served? Where is the service on mineral development?
mineral development, my lord,
They have
service has
Order
started.
number 9.
Yes, yes.
Yes, yes, they have been served.
They have to say something. Because prior to 2015,
I do not find the service. Is it there?
prior to 2015, they are the owner.
DPL is the main authority, the main grievance is against
You
the
have
DPL.
included them as a party if you serve.
Yes.
Please
My lord,
serve
lordship
them.
kindly give a short date because agriculture, my lord,
Short date
cultivation
after
is
the
right.
term,
Yes, yes.
unless you want to appear before some other bench. I have a circuit bench for 2 weeks. So,
Well, it can be wait till your lordship's return, no problem. my lord. The rehabilitation problem is rehabilitation.
It is not his matter. He is appearing
Yes,
for
yes.
the, my lord,
No, no,
DPL. He always, my lord, he appear for the respondent. It is his usual canvassing.
affidavit of service.
Personal কিছু বলছি না।
Affidavit of service. Since
Joseph
service
ফিরে আসা
upon the
পর্যন্ত
ninth
wait করতে
respondent,
কি হবে?
the ninth respondent has to
Ninth
serve.
হয়নি।
Service upon the ninth respondent is not
My lord,
complete.
May I serve directly upon Mr. Saha?
He will not receive. It's on the company.
Yes.
He is not appearing
Yeah.
personally. Is it?
Well, by today itself I can
He
serve.
is appearing for the authority. So
No,
to serve the authority.
My lord, the authority
Authority
can
has to appoint him.
authority can be served, my lord, even by today, my lord. It will also can.
I cannot take up the matter today.
No, I am not saying so. On Friday, if your lord.
Days, Friday not possible. Right, I may have a division bench only first half of the day
My
not possible. Since service upon the ninth respondent is not complete, comma, let the matter stand over till 18th August.
18th.
I'll return that week.
My
Question থাকছে না।
জানি
তা আমাকে চারটে কথা শুনিয়ে দিল এখন বলছে হ্যাঁ মা
বলছো আরে তুমিই তো বলছো কোনো মামলাই
পরের ম্যাটার
আর কি হবে?
প্রাইস লাগবে দেখে দাও না কিছু নেবো না একটা সেকেন্ড
আদার সাইড কোথায়? আদার সাইড কোথায়?
আমি বলতে পারবো হ্যাঁ তাই তো এক্সটেনশন
My lord, next. My lord, next matter. My lord, next matter, item number 22, my lord. I am appearing for the respondents, my lord. My lord, I instructed by the responding authorities to pray for direction for filing affidavits, my lord. So it is.
have to see the file and before giving
Lordship,
directions, come back.
lordship. পরের বেলা হবে নাকি?
208.
My lord, I am for the petitioner. My lord, on the last, your lordship has been, was pleased to heard this matter on diverse occasions. On 12th June, it appears that presence of respondent number 4 and 5, private respondents, are very much necessary for adjudication, but service could not be completed. So your lordship was pleased to adjourn it till today. So I need some extension also. I'm trying to get it by other way, fresh address and the substituted service. Last order of 12th June of your lordship.
You are not aware of the address. What is the difficulty?
But could not be served them at their new address. I have to come up with an application for substituted service. So, but kindly keep this matter in sometime in September. In the meantime, I will file the
Mr.
application.
Shane is appearing in this matter. Monthly list of September?
But kindly in any date in the supplementary list. So,
Learned Counsel for the petitioner seeks accommodation to serve copy of the writ petition upon the private respondents. Paragraph on prayer of the petitioner, comma, let the matter appear under the same heading on 8th September. Get quickly.
Nine.
So I am for the writ petitioner in this matter. My lord, Roshi will remember this is a matter which pertains to license dispute with pertain to license fee in respect of 5 stalls at Asansol. Roshi, on previous occasion, Roshi was pleased to accept my supplementary affidavit.
Who is appearing for the respondents?
Mr. Kollan Chakraborty, he was there in the previous occasion because on his prayer, the matter was adjourned. So I have filed my supplementary affidavit, my lord. There was a submission from the bar that I was not paying the license fee as per the allotment letter. But here in the supplementary affidavit, Roshi will find that in respect of first year and second year of license, I have already cleared. And today I have received another instruction from my client that for the third years of license, which will commence from August 2023 till August 2024, that has also been paid in full. But this is not the part of the supplementary affidavit. This is a subsequent development, my lord.
But I do not find the respondents.
In that
You are
case, my lord,
entering an interim order, so
in-
put them on the same day.
only a lordship will not be there and for the
16.
16th.
I'll be back on
Please
14th, I'll resume.
Extend it till 31st August.
16th, I'll fix on 16th itself.
Fixed.
You'll have a scope for extension.
All 5 matters, my same.
None appears for the respondents. Let the matter appear under the same heading on 16th August. 16th August.
Actually, the interim order is expired on 16th.
Yes. So you'll have a scope on that.
Actually,
If it's not disposed of, it can be extended.
in respect to all 5 matters, my lord, same prayer, same order may be passed. All 5
I'll just call
stalls,
the matters. I'll just call the matters.
same.
Same order. The date is also the same.
Same, my
expiry
lord,
interim
same.
order.
So it's in respect of 1 tender.
211.
Same, my lord.
Same order.
212.
Same, my lord.
Same order.
213.
Same, my lord.
Same order.
Roshi, please enough to keep this on record, my lord, the subsequent
You have to
license.
by way of a supplementary affidavit.
Because it was not a part. I will file another supplementary affidavit.
If you want to annex this document also.
No, it was not a subsequent. Then liberty may be given, my lord. Use a supplementary to annex this one also.
Right. After line 20, none appears it aage given. On prayer of the petitioner, liberty is granted to use a supplementary affidavit annexing relevant documents. Same. তারপরে none appears.
214.
Well, this is my application. Well, I am for the petition.
Service, Mr. Debra?
Yes. No, my lord, your lordship, last occasion, your lordship's order dated 19th July.
Yes.
Deploying instruction from his client relating to this period.
Yes, Mr. Debra.
Well, my instruction is that my work, they have decided, we have already decided to exempt the tax. But some, it is a policy decision, that is why some time is required, they requested.
So in principle, it has been accepted.
Principally, they are accepted. Principally
me
accepted,
record
there is a exemption on, and that subsequent notification has been set aside by this court, they have done, now they have decided.
Now, only thing I am praying, because I have to pay the tax. Whenever it will open, I have to pay the tax. It will be huge burden. In order to lessen the burden, if I pay
The current tax.
current tax from January,
Current tax from January.
from January, backlog, as and when they will decide, we will pay. There is no problem to that extent. Whatever they will decide, we will pay.
Backlog this between that period.
That period.
Rest of the period, they
No
have to
doubt that let them decide first and regarding
Your exemption is from 24th March 2020 to 30th September 2020, and again April 2021 to 30th September 2021.
Yes, I'm not asking
So
for it.
beyond this period, deposit the remaining tax.
Yes, without prejudice.
You're losing any time.
Your vehicle is with the authority, or it's
No,
you're
no,
applying. It is with you.
I'm not flying.
Because it's cooperating.
Two
Two
vehicles,
vehicles
my two vehicles were seized. One have been released, another has not yet been released. But I have advised my client not to operate till any order is passed by the honorable court.
So let me record their in principle acceptance. Principally, they are accepting, and they need you need some more time.
My
for,
instruction, madam, my instruction.
I'll record
on
on instructions. Absolutely.
On
Not
instruction.
be your personal opinion. And tax for the remaining period has to be assessed by the authority. Otherwise, how will you pay?
That's right.
Yes.
That's why
That is,
I am regarding current
that
tax.
is what
It is
some
not
time
required
is
to be-
required.
It is not required to be assessed.
That
Current
no,
tax
no,
I
no,
can
that,
pay.
that has to be required because tax penalty, etc., is there.
Let them assess whatever it may be. But regarding current tax, there is no question of assessment.
Current tax is from July.
That
From
is not,
July.
that is not, well, in the, they have not accepted because earlier, if they
But
not pay.
for non-payment of current tax, the vehicle has been seized earlier.
The writ petition pertains to this period only.
This period.
Yes, the period of exemption. So beyond that, I don't think I can pass an order, not necessary also.
Development.
Why did you approach the authority and take and
Yes,
pay
they
the tax?
approach the authority.
Unless any order is passed by this honorable court, authority will not touch. They will not accept any tax. They will not allow me to apply. That's the whole difficulty. And the vehicle is of the EMI vehicle from the bank.
Let the current tax be paid by the
Current
authority.
tax
by
means
then-
that period accepted.
Except that period.
Except that period, they
Current tax from
approach
July.
before the authority.
I'll mention the petitioner will have liberty to pay the current tax from July 2023.
July 2023, no, my lord, from 30th, after 1st October 2021.
No, that has to be assessed by the
That is
authority.
No, that has to be assessed. That is the exempted period up to 30th September. Thereafter, they have to pay it. Otherwise,
Thereafter, nothing has been paid, isn't it?
no, nothing has been.
So whatever has to be paid has to be assessed by the authority.
My lord,
Otherwise, how can the
Lordship can
petitioner
direct
pay?
them to
I mean, the
assess.
petitioner doesn't know whether it is 10,000 or 10 lakhs.
Yes,
Yes.
Lordship
But
can
the
direct
regarding-
the authority to assess and give it to assessment order. That
Very
will
well.
be better. That will
Let me
be
direct the authority to assess for the remaining period
assess the period, rest of the.
and inform you. Though that is beyond the scope of the writ petition.
That's right. That is why I am praying at the present moment only to that extent.
That is
Only-
not acceptable.
Only to that extent, without prejudice, let them accept from July itself. I have no problem. So that burden can be lessened.
Lordship can direct them to assess and give assessment order.
Deborah, in this writ petition, how can I direct them to assess beyond this period?
If I want to
He has
pay-
only asked for exemption for a certain period.
Yes.
Which you are accepting
Hmm.
in principle.
In principle.
Yes. So beyond that period, it's beyond the scope of the writ petition.
I am
There is
not
no
praying that all. At the
No
present-
order can be asked. It's
I-
I can at best grant the petitioner liberty to
approach
pay
the-
the current taxes and approach the authority for applying for accepting the same.
Bas, only that to the
A liberty can be granted. That's
current taxes along with the penalty or like that. Current tax
that is
penalty
not
cannot-
current. Current tax is this month, from this month. That they'll assess and he has to pay.
The payment to the penalty. Yes, yes. Current. Current tax
It is
also
submitted
right
on
to-
behalf of the respondents, comma, on instructions, comma, that the authority, that the concerned authority has agreed in principle to exempt payment of tax by the petitioner, payment of tax and additional tax by the petitioner for the period 24th March, 2020 to 30th September, 2020, and from April 2021 to 30th September 2021. Stop. The petitioner seeks liberty to pay tax and additional tax
Current.
from pay current tax and additional tax. Pay the current tax and additional tax so that he is able to ply the vehicle which is sitting idle for considerable period of time. Paragraph, such liberty is granted. The writ petition can be disposed of actually.
No, let them submit that. Let them submit their policy decision or whatever it may be.
ওটার পরে কোনো যেখানে ইন প্রিন্সিপাল এগ্রি করেছে বলবেন না ওখানে করুন since the matter involves policy decision of the authority, comma, some time is required for taking a final decision thereto. How long should you take, Mr. Debra? 1 month?
Yes, madam.
Yes?
1 month.
1 month? Come back on 1st September. 1st September. Paragraph, let the matter appear under the same heading on 1st September 2023.
And only one thing, that the approach to be made to the taxing of respondent number 5, taxing officer, motor business department. He is my taxing authority.
Approach him. No need to mention.
Put the concern authority.
I have just granted liberty to you.
We put
to
the
pay
concern. We put the concern.
Yes.
Keep look like valid.
হ্যাঁ
215.
For the writ petitioner in this matter, my lord, this matter has been heard on several occasions. My lord, this matter pertains to one cleaning contract which has been executed by the writ petitioner and the Southeastern Railway. My lord,
Respondents, you are
respondent
appearing?
now, my lord, in respect of one tender issued, petitioner emerged as the successful bidder, and thereafter one letter of allotment was issued in favor of the writ petitioner on 1st September 2021. My lord, that letter of acceptance is in the nature of counter proposal, my lord, but that has not culminated in a formal executed agreement. No agreement is there at present. Now, my lord, after commencing the work, the petitioner of lordship faced some inconveniences. Accordingly, representations were issued, but the railways did not extended any support. Now, thereafter, my lord, the railways, upon giving me 7 days notice and 48 hours notice, terminated the letter of acceptance, but they are saying that it is in the form of a contract. Now, my lord, no opportunity of hearing was provided, and the termination, my lord, your lordship will kindly see at page 37. As page 37, dated 12th of April 2022. She has found, my lord?
Yes.
Yes. So, my lord, lordship will find that 3 tiers of punitive measures have been applied in my case. My lord, may I read for you, lord? For my satisfaction, my lord, may I read that in connection with the interior cleaning and padlocking, unlocking and watering and the platform return stable terminating trains and cleaning depot premises and stabling lines at CKP for a period of 3 years, 7 days notices was given to you under this office letter number MC such and such cleaning dated 1st of April 2022. But your performance has not improved. Moreover, the penalty imposed in terms of clause 11.2, 11.2 H, C and 11.2 G of special terms and conditions of contract for the period of 27th of September 2021 to 13th of March 2022 comes to nearly 1,11,56,000, which is more than 10% of the original contract value. My lord, I am stopping here for a moment, my lord. The original contract value is 20,83,147. It will appear from the letter of allotment, my lord. Now they have imposed a punitive measure, my lord, without providing me the actual breakup, how they have computed that within few months of operating, they have suffered a loss of 1,11,56,000 when the original contract value is of 29,83,147. My lord, no computation was provided. Now, second, my lord, since the period of 7 days notice has already expired, the above contract stands rescinded in terms of clause 7.1 of the general conditions of contract for services 2018 and balance services under this contract will be carried out independently without your participation. Your participation as well as the participation of every member partner in any manner as an individual or a partnership firm is hereby debarred from the participation in the bid for executing the balance services, and your performance guarantee shall also be encashed and forfeited. Now, my lord, this is the second tier of punishment. That is forfeiture of the performance guarantee. That is another punitive measure. In addition, your participation as well as participation of every member partner in any manner as an individual or a partnership firm is hereby debarred from participation in a bid for executing any work being tendered by Chakradharpur Division of Southeastern Railway for a period of 2 years from the date of issue of this letter. Now, the third one is the blacklisting. Now, my respectful submission is before your lordship is this 3-tier of punishment cannot be inflicted upon me at a pre-contractual stage. Now, these are all the punishments which are contemplated under the general conditions of contract and special conditions of contract post-contractual stage. That there has to be a tender, followed up with a letter of allotment. Then there will be a formal execution of agreement. Then the execution of agreement will contain the punitive measures and under what provision these measures can be applied. But nothing here, because only what is in existence was the letter of allotment, my lord, which is at page 29. Now, the only question, my lord, this is I am placing before this honorable
Condition of contract. What is that? What is that?
condition. These are all the general conditions of contract and special conditions of contract, which they have appended in their report, my lord. From their report also.
So this contract was not between you and the authority.
No, there was no contract at all. There was a tender. I emerged as a successful bidder. Now a letter of allotment was issued. It has to
Nothing
be
further. After letter of allotment, nothing.
Nothing has. I have commenced my work. Now the thing is this: they have terminated my letter of allotment, treating it as a contract and imposing these punitive measures, which contemplates that it can only be done after a formal execution of agreement. Pre-contractual stage, these punitive measures cannot be applied. Well, this is the Honorable Supreme Court has also said in the same line, my lord. I will be citing those judgments. Now, my lord, actually, just a minute. Now, my lord, very kindly come to their report, my lord. At page 20, the report filed by the railways. They have appended the tender conditions. Page 20, my lord, may be kind enough to come. It is internal page 6.
Page
Okay.
20, yes.
Of the report, my lord, railways report. My lord, it will be very clear from this particular page that what they have done is not sanctioned by the law. Actually, may I start reading from below the note? The performance guarantee shall be submitted by the bidder after the letter of acceptance has been issued, but before signing of the contract agreement. So I have submitted my performance guarantee, but that has to be before signing of the contract agreement. This performance guarantee shall be initially valid up to the stipulated date of completion and maintenance period, if any, plus 60 days beyond that. In case the time for completion of service gets extended, the contractor shall get the validity of performance guarantee extended to cover such extended time for completion and maintenance period, if any, of the service plus 60 days. Now, my lord, kindly come to the third paragraph. Whenever the contract, my lord, kindly see this. This is very important. Whenever the contract is rescinded, the performance guarantee shall be encashed and forfeited. It is saying that whenever the contract is rescinded, never saying that letter of acceptance or letter of allotment is rescinded. The balance work of service for the same shall be get done independently without risk and cost of the failed contractor. The failed contractor shall be debarred for a period of 2 years from the date of such rescindment from participating in the bid, which includes delivery of balance services of failed contractor. If the failed contractor is partnership firm, then every member partner of such a firm shall be debarred for a period of 2 years from the date of such rescindment from participating in the bid, which includes delivery of balance services of failed contractor in his or her individual capacity. My lord, then the last 2 lines, the contract being determined or rescinded under provision, Lordship, can you see again the word contract? The contract being determined or rescinded under the provision of GCC, the performance guarantee shall be forfeited in full and shall be absolutely at the disposal of the President of India. My lord, these are the punitive measures which in no uncertain terms states that can only be applied in respect of post-contract scenarios. It cannot be applied to the pre-contractual scenarios. I would have understood, my lord, had they withdrawn the letter of allotment, they could have at least done so by refunding my performance guarantee, or by saying that your performance is not good, we are withdrawing the letter. But they have not done so. They have, Lordship, my respectful submission has imposed the punishment upon me, which I am not entitled to receive. Because, Lordship, kindly see what the Honorable Apex Court has said in this. May I, Lordship, refer to AIR 2017 Supreme Court case 2035 regarding imposition of damages and the punitive measures, my lord. Lordship, kindly come to paragraph 13. Lordship has found paragraph 13. Because they have imposed me a punitive amount of 1 crore 11 lakhs when my contractual amount was only 29 lakhs. When they can issue it, when they can impose such punitive measures, it has been stated here. The section 7 of, Lordship, paragraph 13. Section 7 of the Indian Contract Act, hereinafter referred to as the Act, provides that in order to convert a proposal into a contract, the acceptance must be absolute and unqualified. The existing of a concluded contract is a sine qua non in a claim for compensation or loss or damages under section 73 of the Act, arising out of the breach of contract, if instead of acceptance of proposal, counter proposal is made, there is no concluded contract comes into existence. So far as the quantum of the punitive measures, my lord, which they have imposed, my lord, that cannot be applied until and unless there is a concluded contract. My lord, section paragraph 16 also in the concluding portion also says in the same line that in absence of a concluded contract between the parties having been established by the respondent, the claim under section 73 of the Act was not maintainable. And the impugned orders are therefore held to be unsustainable and are set aside. My respectful submission, my lord, there is no contract. And it is the statement of the railways also in page 4 of their report that there is no contract.
There is no?
No contract. Page 4, my lord, of their report. Lordship, kindly come to page 4. Paragraph, my lord, the first 2 lines. But the requisite documents, my lord, has found. But the requisite documents as opined by the law officer have not yet been submitted by the firm, Mrs. Ganesh Prasad Singh Bilaspur, due to which the agreement between the Mrs. Ganesh Prasad Singh Bilaspur and DME CKP Southeastern Railway could not be executed till the termination of the contract. Again, the word contract, my lord. This cannot be a contract. This is an LOA. There has not been a concluded contract. And so far, my lord, as the penalty which they have imposed, Lordship, kindly see what they have stated. at page 6 of their report. Paragraph 17. Actually, may I read, my lord? It is stated that the penalty has been imposed to Mrs. Page 6, my lord, of the report of the railways.
Paragraph 17.
Yes, paragraph 70, my lord. It is stated that the penalty has been imposed to Mrs. Ganesh Prasad Singh Bilaspur following the terms of general conditions of contract for service of 2018 and special conditions of contract of railways. Total penalty imposed for the period from 27th of September 2021 to 13th of March 2022 against LOA. Lordship, kindly mark this thing. Number such and such, dated 1st of September 2021, is rupees 1,11,56,000, my lord. Now, this is how they have stated here, but they could not be able to at least justify how this amount they have come at. Because it kindly see, my lord, the period for which I have worked, that is 27th of September 2021 to 13th of March 2026 months I have worked. And for though I have worked and completed my at least my portion of the job, but the damage has been ascertained as 1,11,56,000. So this is at all not tenable, because the special terms and general conditions. My lord, I have stated at paragraph 9 of my writ petition under what circumstances they can charge me. What is the quantum? Page 9 of my writ petition.
Yes.
Paragraph 9. Your petitioner states that the amount of the penalty imposed on the petitioner, that is 1,11,56,000, has been computed in terms of 11.2H, 11.2C, 11.2G of special terms and conditions of contract being reproduced herein below. 11.2H, if the contractor fails to provide minimum manpower as per clause 1.1 of the project resources, then a penalty of rupees 20,000 per instance will be imposed. 11.2C, for shortages of non-supply of any contract deliverables, including cleaning chemicals, cleaning tools, etc., other than the proportionate deduction of the cost, will be made by the railways. Additional penalty of rupees 2,000 for each item will be imposed per day. If the contractor fails to stock 1 month quantity of consumables and cleaning agents as per clause 3 and 4 of the project resources, then a penalty of rupees 2,000 per instance will be imposed. From the perusal of the aforesaid clauses, it can be deduced that the amount of rupees 1,11,56,000 has been foisted upon the petitioner cannot be substantiated in any manner whatsoever. Moreover, while computing the same, the railway authorities are duty bound to give a detailed report substantiating as to when the said infraction has taken place and how the said computation has been done, and in absence of the same, the said computation of the said amount is honest in the eye of law and liable to be set aside. So, my lord, this is my respectful submission so far as the first punitive measure is concerned. My lord, so far as the second one is the forfeiture of the performance guarantee, as per their own report, my lord, it says that it can only be done if there is a proper contract. Before that, it cannot be imposed. And the third one is the blacklisting, my lord. It has a civil consequences for which they have to give me a prior notice. So there are catena of judgments, my lord, that before blacklisting me, I should be taken into confidence. An opportunity of hearing should at least be provided to me, so that at least I can substantiate my case, but that opportunity was also taken away. Now, my lord, let my learned friend demonstrate that the punitive measures that they have applied can be imposed upon me at a pre-contractual stage. Now, my lord, there is a Supreme Court judgment on this, my lord, followed by the Honorable Single Judge. May I hand over? 2006 Volume 1 Supreme Court Cases 751, my lord.
2006 Volume 1.
2006 Volume 1 Supreme Court Cases 751. It is paragraph 32. My lord, may I hand?
Have you given the citations to learned
Yes,
counsel?
yes. my lord, paragraph 32, because this is the particular paragraph, my lord, it has been followed by the coordinate benches of this honorable court in these cases. Lordship, paragraph 32, my lord, has found.
Yes, 32.
Lordship, parties agreeing upon the terms subject to which a contract will be governed when made is not the same as entering into contract itself. Similarly, agreeing upon the terms which will govern a purchase when a purchase order is placed is not the same as placing a purchase order. A prelude to a contract should not be confused with the contract itself. The purpose of revision 4 dated 10th of June 1991 was that if and when a purchase order was placed by Bindal, that would be governed by the general conditions of purchase of Bindal as modified by revision 4. But when no purchase order was placed, neither the general conditions of purchase nor the arbitration clause in the general conditions of purchase became ineffective or enforceable. Therefore, initialing of revision 4 by Dr. and Bindal on 10th of June 1991, containing the modification to the general conditions of purchase, did not bring into existence any arbitration agreement to settle the disputes between the parties. My lord, as there is no agreement, my lord, arbitration is not the remedy. Now, my lord, this particular judgment has been followed by a coordinate bench. My lord, I have handing over. A similar issue came up for consideration, my lord. It's unreported one. I am supplying one copy to my learned friend, my lord. I will not trouble your lordship with the entire order, but only the operative portion, which starts from page 7. My lord has found, my lord.
Yes.
Having heard the parties and considering the material space, this court arrives at the following findings. Having regard to the law on concluded contract, it is an accepted proposition that a tender document is in the nature of an offer to the whole world and cannot give rise to a specific concluded contract between the tender offering authority and the highest bidder. The highest bid as submitted by the present petitioner qualifying in the tender would be subject to several terms and conditions specified by the tender document, as would be evident from the offer letter dated June 19, 2017. It is upon the acceptance of such terms and conditions by the highest bidder and the communication of such acceptance to the tender issuing authority that the tender agreement is executed between the parties. The other conditions in the tender documents and the railway policy can kick in only after the parties have entered into a concluded contract. It is obvious to this court that the offer letter dated June 19, 2017 refers to a commencement of the work by the successful bidder in the case of the petitioner by applying clause 20.1 of the tender conditions only after the allotment of the contract. The time period of commencement of such work is also specified in clause 20.1 SUVRA. It is also obvious that no allotment of contract by signing the agreement between the parties had taken place between the parties. The petitioner, even prior to the signing the contract agreement, had sought extension of time to sign the contract and thereafter refund of SD and EMD. It is evident that the law has been correctly noticed by the Honorable Single Bench in 2006 Volume 1 SCC 751. My lord, just now I have cited that till the parties entered into a concluded contract agreement, no arbitration clause contained in the contract agreement can be operative against either of them. This court also finds the ratio of AIR 2017 SC 2035. My lord, I have also cited in the first instance. Apropos the facts of this case, since the offer letter dated June 19, 2017 was more in the nature of a counter proposal by the Eastern Railway, the respondent specifying the requirement of compliance of further terms of the conditions by the petitioners. Now, in the view of the matter, WP number stands allowed, my lord. So this is my respectful submission, my lord. The punitive measures have been imposed prematurely. The general conditions of contract, special conditions of contract can only be attracted and applied when there is a concluded contract. So when there is a no concluded contract, my lord, these punitive measures cannot be applied. My lord, my respectful submission, my lord, Roshi, at the very beginning of intending this writ application, my lord, has stated this on the basis of my submission then. My lord, my respectful, let the termination notice be set aside, Lordship, and that they return the performance guarantee, my lord. And because none of them has the support and sanction of the law. Yes, and the order of termination also is without any reason and without any material particulars.
Yes.
Kindly come to page number 33.
Of the writ petition.
Performance notice, not of the writ petition.
Thirty-three.
33 performance. notice.
Yes.
So from the performance notice, the kindly come to para 2, para 2, II.
Yes.
Performance 33. As per clause number 1.18, you had to upload the detail of all such stuff, such and such. It is pertinent to mention here that the work commenced on 7/27/9. Because it got
Yes.
paragraph 2,
Yes, yes.
II. Performance guarantee have been submitted on 7/9/21. 7/9/21, when the letter of acceptance is given on 1/9/21. Within 30 days, performance guarantee has to be submitted. When the performance guarantee has to be submitted within 30 days, and the performance guarantee amount has to be submitted. And
But where is the contract?
the comments from date 27/9/21. Already when the contract has been commenced, work has been commenced, from that day, the procedure has to be.
There should be a written
Yes,
contract.
there should be the contract, but he has submitted, with the document has been submitted, seeking for submission, request for document submission. At that time,
Submission of which
the
document?
submission that submitted the power of attorney and authorization letter. That has been
that is not
given.
material.
Yes, that has not been, required document has not been given at the particular time. Thereafter,
There should be a privity of contract between the parties in order to impose penalty. That is
Yes,
what the law
when the
says.
as per my submission, my lord, when the work has been commenced from 27/9/21, it came to be a contract. Because until and unless when the tender notice has been given, tender notice bidder
Can you show me any rule or provision which says that the letter of acceptance can be deemed to be a contract?
Deemed to be a contract, on that basis, work has been commenced.
Can you show me any rule or any?
That in this general terms and condition, in this present moment, I can show. If on that point, it kept in advance, that I can show on letter after conference of the of competent authority.
How can a letter of acceptance be synonymous with a contract?
The-
Contract is drawn up on the basis of the offer, isn't it?
Actually, on this basis, letter of acceptance on this basis, work has been commenced. Thereafter, some
Any document to
was
show that
required,
your letter of
authorities were
acceptance is
required.
treated as a contract? Any document?
This moment I have.
You have to at least treat the letter of acceptance as a contract?
Actually, on this acceptance, on this basis.
That cannot be a contract.
In the present moment, I can. If your lordship grant some time to I can.
Can you show that in future also?
I have to consult with that. On that basis.
Because a letter of acceptance can be called a contract only when there is an endorsement to that effect.
Yes.
That the letter of acceptance is treated to be as a contract.
On
Yes.
that basis.
So no further contract is necessary.
Yes, ma'am.
Otherwise, there has to be a contract.
Yes, ma'am.
So unless there is privity of contract between the parties, how can this penalty be imposed? These are the questions which are coming to my mind. So why don't you answer these questions?
Your Lordship want to.
Otherwise, the petitioner prima facie has a good case.
On this basis, I have to take clarification.
Please
from
go through the judgments also.
Yes, ma'am.
The same point has been dealt with in the judgments. By
It
this
is
court as well
admitted
as the
that
of the Supreme Court.
they started work. It is admitted on the basis of LOA. They started work and comments from such and such 27/9/21. And your Lordship queries that the whether the LOA is deemed to be a contract or not.
Yes, yes.
That
yes.
has to be clarified.
Because this is not between two private individuals.
Until and unless contract is executed.
This is an authority who is doing it.
GCC and special terms and conditions whether apply or not.
Yes, yes.
Then come to
Then
penalty
penalty.
provision and
If you
other
can
things.
show a document that yes, the special terms and conditions apply to a letter of acceptance also, which is treated as a contract, then the penalty is all right.
I have to clarify.
Please clarify and come back, and please go through these judgments also and come back. If you can distinguish them.
Lordship, only one thing, my lord, from their own report, it is quite apparent, my lord, that these punitive measures can only be applied in a
No,
post.
there is no contract that is admitted. Learned counsel says that since you have commenced work on the basis of the letter of
It's a
acceptance,
counter proposal, my lord. It's a nature of counter proposal. I'll kindly see the writing. The letter of allotment says that you have to do this, you have to do that. These are all the counter proposals that has not channelized into a formal agreement. Kindly see the letter of allotment.
this is the
This is the
primary
only
issue.
question, my lord. Oh, this is
So let learned counsel come back with instructions. on this.
instructions, but my lord, I fear, my lord, he won't be able to because he has himself admitted that there is no agreement and contract. And neither the point which I
So
have
admittedly,
raised.
there is no contract. Only thing is whether the letter of acceptance has been treated to be a contract.
Then there has to be
and
unqualified
whether-
acceptance on my
yes,
part.
And whether the special conditions apply.
Lordship, my respectful submission is this, one, subject to Lordship's kind approval. The general conditions of contract and special conditions of contract from the very line it states that it's only applicable in cases of the contract. It never says that letter of allotment or letter of acceptance will be guided by that. Because Honorable Apex Court has made it very clear. The distinction is quite clear in nature. And the points which I have raised in the writ application, my lord, that has not yet been dealt with. The only question, this is the only question which requires to be Lordship, adjudicated upon. Yes, Lordship, kindly come to the page 30. This will make position very much clear. Page 30.
30.
Yes.
Of
This
the
is the
petition.
offer letter, my lord, which my
Yes,
learned
yes.
friend is. Page, internal page 2. That it says, page 2 of 3, that decision of
Page
the
30
authority.
of your writ petition.
Yes, yes, yes.
Internal page 16 in page.
No, no,
30.
my lord. Page 29, the offer letter starts. Page 29.
Oh, yes, yes, page 30.
Then, Lordship, kindly skip to the next page. This is the letter of, they say it's a letter of acceptance. Now, Lordship, kindly see what they are stating. First line, decision of authority competent to sign the contract agreement would be the final in case of any.
This is,
The letter of part of LOA.
no, where are you reading? Page,
Page 2.
yes, page 2.
The
Which line?
decision, first page, first line, my lord. The decision of authority
Competent to sign.
competent to
contract
sign the contract would be the final in case of any reason. So this is not the final terms and conditions. There has to be a mutually agreed terms and conditions by both the parties and has to be signed by both the parties. Now, you kindly see, they are saying that these are required. So many thing has been stated. These are their terms. That is the reason I'm saying it's a counter proposal.
And learned counsel pointed out that the work was commenced. The second paragraph says, the entire work will be completed 36 months from the date of issuance of letter of acceptance, not contract. So by virtue of this, work had commenced.
Yes.
Contract was supposed to be executed in the meantime.
Yes.
That has not happened.
Yes, in the performance guarantee for the special terms and condition, there is a when the performance guarantee amount is deposited, thereafter
Contract
the
has to be
contract
executed. That has not done.
by signing the competent authority. That as per this record, from the record, it is found that the
It has not been done.
There's no.
There is some document has to be required because we send the document for document authorization document to Manoj Kumar King something other and power of attorney. So that has to be sent for vetting with the officer. That come after that, there are some document also will be PAN card and another thing also be recovered. For this reason, contract has not been executed.
Lordship, kindly record these subs. This will be, I think it will be helping my case.
So, from the your lordship query is that the whether on what basis the penalty and general terms and conditions GCC and special terms has been applied, whether there is no contract. So if my respectful submission, I have to
idea to the authority, they will do this.
No, they will
And
not.
you are responsible for it.
No, I am. Lordship, kindly see, my lord.
Nothing has been done till date. Why are you bringing up this issue? There was an interim order earlier.
Yes, my lord. Staying the termination, my lord.
Staying the termination. So let that be continued for some time. And please come back in the meantime with the instructions.
Lordship, let them file an opposition, my lord. Affidavit in opposition. That will be better. They will be able to substantiate their stand.
I don't think they can improve the case by an opposition. I
Then in
don't
that,
think so.
because
this is
only has to be satisfied until and unless contract is executed. Other part, GCC and penalty.
Or whether by virtue of consent of the parties, this has been deemed to be a
contract or not. On that basis,
that cannot be unilateral. And let me mention this. It has to be on consent of the parties.
Yes.
And whatever counter proposal they are giving, my lord, I say it's a counter proposal because
7 days notice and termination notice has to be issued or not.
there has to be unqualified acceptance of this one.
Notice has to be issued.
Yes.
You cannot terminate without notice.
Notice
That's a
has been
different
given-
aspect.
Notice has been given only first point is that
No hearing was taken.
contract is why he
The primary issue is whether you could have issued this notice and imposed penalty at all on the basis of the LOA without a contract.
Yes.
So please consider this and come back. It is not in dispute that the petitioner commenced work in terms of
27/9/21.
yes,
27/9/21 page 33. Page 33.
Annexure P2.
Commenced work in terms of the letter of acceptance issued in his favor on 1st September 2021. And no contract was executed by and between the parties subsequently or till date. Paragraph, learned counsel for the petitioner submits that in absence of a contract being executed by and between the parties, comma, the respondents could not have page 37 is your termination.
Termination notice, 37. Annexure P4.
Could not have imposed penalty upon the petitioner in terms of the special terms and conditions of contract, since no contract exists at all. Learned counsel has placed reliance on the authorities in এই তিনটে রেকর্ড করবেন তো মেসার্স বেদান্ত লিমিটেড পুরোটা নেবেন না আমি জাস্ট প্রথমটা বলে দিচ্ছি আমি পুরোটা করে নেবেন মিসেস বেদান্ত লিমিটেড ফর্মালি নোন অ্যাজ যা যা আছে ভার্সেস মেসার্স এমিরেটস ট্রেডিং এজেন্সি এলএলসি রিপোর্টেড ইন AIR 2017 সুপ্রিম কোর্ট 2035 মানে পুরোটা এইভাবে লিখবেন হ্যাঁ কমা ড্রেসার র্যান্ড এসএ versus Bindal Agrochem Limited. Reported in 2006, Volume 1, Supreme Court Cases 751 and a judgment of a coordinate bench of this court in WP number 26079 within bracket W of 2017 in support of his contention. Paragraph, learned counsel for the respondents seeks to take instructions in this regard. Paragraph, let the matter appear under the same heading on 23rd August. Paragraph, the interim order granted earlier is extended till 31st August or until further orders, comma, whichever is earlier.
Grateful, ma'am. Grateful, ma'am.
Next. 216.
For the petition.
এটা প্রথমটা তো কি বলছো 13,500 নামটা মিলেই না তো একটু
Mr. Sen, you wanted to submit a report in
My lord, it is here. And copy already sub, my lord.
today my lord I have got the
I'm
copy.
sorry, my lord, my clerk, my lord, mistake.
No problem.
It was
no
affirmed, my lord,
My lord,
possibly
I have gone
Friday.
through, no, my lord, no reply is necessary. my lord.
necessary, very
My
good.
lord.
Very good. Payment. Gross vehicle weight.
Mine.
What does the report say?
My lord, lordship kindly turn to page 5 of the my lord affidavit. My lord, this is instruction in respect of WPN number 5369/2021. Another writ petition. This is my lord issued by the my lord director.
Now, my lord, I have handed over last occasion, my lord, the order passed 5369/2021, my lord Justice Mousumi Bhattacharya. This instruction negated and granted, my lord, order in favor of the writ petitioner, directing the authorities to refund the
Yes, so the 5% relaxation is there in both the notifications.
And my lord, lordship, kindly see the server copy of the order, my lord, passed in 5369 of
Yes, I've seen the order.
Man,
I've
man.
seen.
So, my lord, this is a very clear case, my lord. I am entitled to get back the my lord, fine which they have, my lord,
Mr.
taken.
Sen,
My lord, in fact, my lord, that is now, my lord, the clarification by the Director Transport that, and that was obviously, my lord, which, my lord, in respect of instruction, it was practically a general instruction. In any event, it was used in 5369. Now, my lord, it has been clarified by the director in this way that for the purpose of that notification, the expression that is in the explanation mentioned at page number 16, the 16 or 22, 16.
16.
The explanation part at the bottom that for the purpose of this notification tolerance
number?
up to
Page number 16, 16.
that
Yes.
petitioner, my lord, relies upon.
Yes.
That for the purpose of this notification tolerance up to 5% in the gross vehicle weight shall be allowed for the purpose of compliance to subsection 3 of section 103 of Motor Vehicles Act. Now, this particular, my lord, the expression that for the purpose of this notification, now, my lord, the instruction that it appears from the Director Transport that prior to this notification is dated 16 July 2018.
Yes.
Now, by this notification, my lord, the Ministry of Road Transport and Highways, now, my lord, just made it that the axle weight or gross vehicle weight, that maximum safe axle weight in case of single axle 3 ton, in case of single axle 2 tire 7 ton, that means that henceforth it should be this. So, my lord, the clarification that already come, my lord, it appears according to the Director Transport
That means that the vehicle already registered. The vehicle already registered. This, my lord, the exception that is carved out in the explanation, or my lord, the benefit, that is the, my lord, the exemption of up to 5% tolerable limit. That is only for the vehicle already registered, though it is not mentioned here in specifically. But the vehicle which registered after the notification, that means, my lord, the fresh vehicles, in respect of which, my lord, their RC book, their respective registration certificate book contains the modified, is, my lord, the axle weight or gross vehicle weight, then they are not entitled to.
Where is that stated? That it will not be, that is not stated here.
It is not specifically mentioned
So it
there.
has to be applicable to vehicles which are registered after this also.
It is not specifically mentioned there.
So we cannot give such an explanation.
But
We cannot add to what is already there.
that is true.
Have you
But
seen the earlier order of a court?
No, my lord,
bench?
yes, my lord, earlier order, that means, oh, in that matter.
It's exactly on the same issue.
I see.
Both the notifications have been, and the petitioner gets benefit of both.
But this question, my lord, this issue was not there, I think.
This issue was there. The two notifications are were under consideration.
Yes, first and second notification. No, I am not on that. I say that whether the vehicle already registered on the date of issuance of notification and the vehicles which registered after the issue of
Why is this
notification,
issue coming up? I do not follow.
because the vehicle that would be registered on the date of notification, that, my lord, naturally, in their RC book, as per the notification, my lord, whatever the gross vehicle weight mentioned therein, that would be mentioned.
Yes.
But the vehicle which were registered back to that, in that case, this explanation practically, my lord, applicable, though it is not specifically mentioned therein. And this issue, I think, has not been gone into.
My lord, this issue, my lord, it is mentioned in the order, my lord, second page, second paragraph. The prayer of the writ petitioners is opposed by the learned counsel appearing for the state who relies on a letter dated so and so under clause number 4, whereof approval certificate granted prior to 16 July 2018 only be considered. My lord, this point, my lord, raised by the, my lord, state government before the honorable court, my lord, at the time of hearing, that was considered, and thereafter, my lord, this order passed. No appeal has yet been preferred. Order reached its finality.
Where is the 6th February circular, the earlier circular?
My lord, 16th July 1, and another is, my lord,
6th February.
6th February. My lord, that is, it is, my lord,
That is not
after
relevant.
6th.
That
No,
is not relevant.
no,
that is not here.
That is not.
And where is the RC book of the vehicles?
My lord, registration
Showing the
certificate.
gross vehicle weight?
My lord, my lord.
At page 20, possibly.
Page?
Page 20, my lord.
Yes, please, page 20, my lord. right hand side 47,500.
Date of registration, Lordship, at the top, right hand side, top 10th August 2021.
That is after the notification.
After notification.
And the gross vehicle weight,
My lord,
47,500.
So far my understanding, my lord, there is no such, my lord, that after those who registered vehicle after 18, my lord, that will not come within the zone of this consideration. My lord, according to my understanding, my lord, there is no such, my lord.
না, ও টাকা দিয়ে দিয়েছে।
টাকা দিয়ে দিয়েছে, ও টাকা দিয়ে ছাড়িয়ে নিয়ে গেছে, মাল বিক্রি কি করবে, আগে তো মালটা পৌঁছে দিতে হবে।
My lord, instead, my lord, so far this matter is concerned, if your lordship, my lord, allow me to say, since, my lord, the person concerned, the motor vehicle inspector, on the basis of his, my lord, available this document, now, my lord, he has filed this report. Now, my lord, at the present moment, if your lordship allow me to say, at the present moment, since he has paid the amount, the whatever the penalty slapped upon him, he has paid. Now, if your lordship, my lord, think it that this matter is to be gone into for this purpose, then, my lord, I think that director transport be file a report for once and all.
Not necessary. It will only prolong the matter. It will only
My lord,
the matter.
pardon me, my lord, in earlier repetition, that is,
No,
my lord,
why I say
5369,
so?
director, my lord.
Why I say so? Motor vehicle inspector, my lord, is not, my lord, representing the such a, my lord, the position with regard to this. That is why I say, because this matter, since the motor vehicle inspector, he intercepted and he issued the challan. So that is why, my lord, this affidavit has been filed. So far the facts are concerned, he has filed this affidavit. Now, my lord, I think that, but so far this particular issue with regard to this notification and this clarification,
Will it improve your case, Mr. Sen? If it improves.
no, I am not exclusively for
Otherwise-
this. For
My lord,
the
director,
for a
director
general,
has
my lord,
already, my lord, issued the
For-
clarification in the
for
earlier
once and all.
repetition.
That whether
Actually, what learned
My
counsel says is the issue has been clarified in the earlier.
Already clarified by the director.
So I don't think anything.
And
any
that was
further
considered-
action will take place.
I leave
I
it
don't
to
think so. Let us deal with this matter as it is.
my lord. Now, my lord, so far there are, my lord, our only this other, my lord, the offense and the fine also.
The other offense, he has no dispute. He is only disputing the overweight part.
5%. Regarding, my lord, negligence driving or rash driving, my lord, I have nothing to say. Because, my lord, it is the opinion of the, my lord, concerned motor
Yes,
vehicle
yes.
inspectors that it was, my lord, running, my lord, dangerously. So, my lord, this is not a, my lord, trial court, my lord, for taking evidences. So, my lord, I am not one.
Only that part he is assailing, not the entire
My lord.
document. Yes, so let there be a similar order.
To that extent, to that
That
extent.
extent, yes.
Now, my lord, so far refund is concerned, my lord, I do not know, my lord, that who is the appropriate authority, my lord, better, my lord, the
In the earlier matter, you had suggested the regional transport authority.
regional transport authority.
It was your submission before the coordinate bench.
I see. It was the submission on behalf of the state.
Yes, Mr. Debra was appearing there.
Yes, now, my lord, it would be better, but not, my lord, we do not, my lord, use it that my submission. It would be better that the head of the district be directed, because head of the district is, my lord, as well as the chairman of all, my lord, the RTA is the, my lord, the district magistrate. He is the collector also.
will he be in a position to refund the amount?
হ্যাঁ সেক্রেটারি কোন ফান্ড থেকে দেবে এটা অনেকগুলো ব্যাপার আছে না রিফান্ডের ব্যাপার থাকলে কে দেবে আগেরটা কি রিফান্ড হয়েছে না আগেরটা হয়নি হুম 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 হ্যাঁ 5% 5%
এরকম ভাবে রেজিস্টার করছে আর একদম বড় পেছনে লাগিয়ে নিচ্ছে মডিফিকেশন করছে
my lord kindly direct that my lord the better very good my lord in terms of earlier order অনুযায়ী
Yes.
টাকা রিলিজ হয়ে গেছে
ওটা আমি জানি না
I just, my lord, I want to, my lord, I do not want to, my lord, that any problem would be there with regard to refund. So that is why, my lord, that to get rid of all these things, that well, I have doubts that whether secretary can do it.
The nomenclatures are also not correct. Registrar transport officer, there is no one called registrar transport
no.
officer. Assistant registrar
No,
transport
no, no,
officer.
that is not correct.
Nomenclatures are also not correct.
Also not correct. That should be,
additional regional transport officer additional
no, 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 এটা registered
Oh,
transport officer,
registered.
এগুলো হয়
it is not no registered transport
হয় না।
correct করতে হবে
Lord, kindly give me liberty.
assistant additional
Let him implement the proper authority as a respondent and he can deal with it.
Lord, kindly allow me to, my lord, implement the correct respondent as a
Yes,
party,
yes.
my lord.
Because, my lord, one thing very, my lord, that putting the money to the government corpus or fund, my lord, that is very easy. But,
Bringing
my
out is
lord,
very
disbursing the same, then, my lord, who is the very rightful person, very
That's
difficult.
why the courts are here.
Otherwise, my lord, then contempt and the contender would come and say that I am not the authority. So everything that would be in miss. That is why.
This order was, the earlier order was in 2021.
I do not know
And
whether
there
complied
is no
with or not.
contempt till now. That means it has been complied with.
কি গো দেবরয় earlier order এ contempt হয়েছিল জানো
no
He's not facing contempt.
no I'm not facing court.
So that indicates that it has been
Yeah.
complied with. So the authority was the regional transport authority.
মানে order
এইটা ভুল হয়েছে regional, it should be
Order-
regional.
yes actually yes regional transport officer or the secretary regional transport authority is the same. RTO or the secretary RTA of a particular region is the same.
Yeah.
Would your lordship be, my lord, I do not know whether it would be appropriate or not, that direction upon the regional transport officer of the concerned RTA. Very good, lordship, let it be.
regional transport
So
officer
he has to be added as a party.
My lord,
regional transport
pardon me, my lord, respondent number 3, my lord, here I have, my lord,
No, no, এটা ঠিক হয়নি,
register.
register হয় না,
It should be, my lord, region.
Region.
So, my lord,
amend করতে হবে।
correct, my lord, permit me to correct the same.
Let him make necessary corrections.
My lord.
On prayer of the petitioner, acha, প্রথমে a report in the form of affidavit submitted on behalf of the respondents is taken on record. Paragraph on prayer of the petitioner, liberty is granted to correct the cause title of the writ petition. Paragraph for learned counsels for the parties.
সেটা তো কিছু করার নেই, সেটা আপনি কি করবেন? My lord, can you record that the report filed?
Yes, I've recorded.
এটা কি? What is this?
The petitioner seeks refund of the penalty imposed upon him for alleged
এটাতে কি আছে দেখি?
excess
আগেরটা কে ছিল?
load
জলদি জলদি নাম দিই
in
এই জলদি
both the vehicles of the petitioner. Paragraph. Penalty of rupees 22,000 for each of the vehicles of the petitioner. Comma. Total penalty being of rupees 22 and 22. Why 54?
22.
So it should be 44.
No, only 22, my lord. Lordship, kindly come to page.
22 and 22.
22 and 22.
So 44.
44.
In the prayer portion, it is, you have stated 54?
No, 54 is the total.
Total.
Include
The fine slab in
Oh,
in respect of
5,000 each.
Another 10,000.
My lord.
কি বললাম? Comma, total penalty being of rupees 44,000 was slapped on the petitioner for carrying excess load. Stop. Penalty of another 5,000 for each of the vehicles was imposed on the allegation of dangerous driving. Stop. The petitioner seeks refund of the penalty of rupees 44,000 paid by him on the ground that the vehicles of the petitioner was well within, that the load of the vehicles of the petitioner was well within the permissible limits. Paragraph. It is submitted on behalf of the petitioner that the
ওই বিপটা কোথায় গেল?
weight
কোথায়?
of the petitioner's
এটা চলছে মামলাটা।
vehicles was assessed at 47575 kilograms and 47540 kilograms respectively, which is
এটা আপনি ছিল ওদের বইটই চলে গেছে একটা সেন্ট্রাল বুক
which is Nakore, whereas the petitioner is entitled to the benefit of the circular issued by the Ministry of Road Transport and Highways on 16th July 2018. কি বললাম এটা sentence টা? 18. Allowing tolerance up to 5% in the gross vehicle weight. For the purpose of compliance of section 113 within bracket 3 of the Motor Vehicles Act 1988. Paragraph, learned counsel for the respondents submits that the explanation to the notification suggests that the notification is applicable in case of vehicles which were registered prior to issuance of the notification and not after. Stop. The petitioner's vehicles being registered after issuance of the said notification are not covered by the same. Paragraph. Upon consideration of the submission made on behalf of the parties and material on record, this court is inclined to hold that there is no indication in the notification dated July 6th August 2018, right? 16th July 2018, that it pertains to vehicles registered prior to the said notification and not after. Stop. The notification clearly demonstrates that there shall be a relaxation of 5% in the gross vehicle weight for the purpose of compliance of section 113 within bracket 3 of the Act of 1988. Therefore, the petitioner is entitled to the relaxation offered by the notification and resultantly entitled to refund of the penalty paid by him for alleged excess weight of his vehicles. Paragraph accordingly, the writ petition is disposed of, directing the third respondent to refund the penalty imposed upon and deposited by the petitioner to the tune of rupees 44,000 for alleged excess weight of the vehicles within 3 weeks. from the date of communication. Yes,
Better it would be 4 weeks.
4 weeks. Within 4 weeks from the date of communication of this order.
Malad, without
Because I don't
interest.
know that Malad file has to be
Yes.
sent.
Malad, without interest.
Interest.
Please get the principal amount.
উদ্যোক্তি করে নিলে তো দিতে হবে ফেরত।
Disposal of chapter.
না সেটাই তো কথা, ওই জন্য জবরদস্তি নিতে হবে।
Yes, hearing matters. The point.
এখন আর সময় চলে গেছে।
জিজ্ঞেস বলে রাখুন না। Same ছিল তো ভাই।
না সেম নয়,
223.
এটা জলদিকে দিয়ে দাও। এটা কি আনলো?
Yes.
I understand this will continue. I had a talk with CCP. He is saying that he will take the whole day to reply.
Whole day. It's only 1 hour left.
Just 1 hour.
1 hour. But I'll conclude my agreement. Malad, the other day, কি করবে?
So I'll release the other matters.
Malad.
It takes 1 hour, then.
For the day except item 23.
হ্যাঁ, রিলিজ। ঠিক আছে।
Petitioners are there. Your
Or the other day, my lord, I was trying to impress upon your lordship with regard to the fact the writ petition is not maintainable because challenging the cancellation of the lease deed, this writ petition has been referred. Secondly, with regard to the fact the authority of the state to cancel the lease deed because of admitted position of fact, breach of the conditions of the lease by the lessee and allotting the land for a public-private partnership purpose, which is the breach of the conditions. My lord, I was trying to impress upon your lordship with regard to that. Now, my lord, whether, and my lord, the most important submission which was made on behalf of the petitioner subject to, my lord, can sanction by the petitioners is that I, on the one hand, say that West Bengal Social Welfare Board is an organ of the state, and on the same tune, I say that whatever the West Bengal Social Welfare Board has done is completely illegal. Whether I can say make such submission or not, being an alter ego of the state, whether the West Bengal Social Welfare Board, whether I can frustrate the contract which was entered into by and between the petitioner and the West Bengal Social Welfare Board. And I represent both the authorities, my lord, West Bengal Social Welfare Board as well as the state respondents. I'm being very candid to your lordship. But this was all these submissions, my lord. I have taken your lordship with regard to the different clauses of lease deed.
Yes.
And my lord, it cannot be denied that the avowed purpose of the lease, which was wholly for the purpose of setting up a working women's hostel, was diluted by the West Bengal Social Welfare Board, which ought not to have been done.
Yes.
Now, my lord, concluding my argument, my lord, last day I submitted before your lordship that I will be placing reliance with regard to whatever I have submitted before your lordship with reliance upon certain judgments.
Yes.
So first of all, I'll start from this honorable court only, my lord. There is a judgment reported in AIR 2012 Calcutta 36. This is with regard to maintainability of this writ petition.
56.
36, my lord, 36.
Yes.
Lordship may kindly turns to paragraph 19, which is at page 40 of the said reported judgment. I am placing reliance upon, my lord, your lordship may kindly mark that. I am placing reliance upon paragraphs 19, 20, and 24 to 27. Paragraph 19 at page 40, my lord. May I read it for your lordship? In case of determination of a private law lease, the only question is whether the determination is according to the lease. And the question is to be adjudicated only in proceedings or suit instituted seeking private law remedy. Adjudication of the question by the High Court under Article 226, applying the concept of fairness, reasonableness, and non-arbitrariness in state action enshrined in Article 14, will be entirely dehouse the terms and conditions of the private law contract between the parties and hence an impermissible act. None of the authorities relied on by Mr. Mukherjee even remotely suppose the proposition that when a state within the meaning of Article 12 cancels a private law lease asserting right under the lease and not by authority of any law or by an executive action, the lessee cannot question the action under Article 226, contending that since on the facts the cancellation is unfair, unreasonable, and arbitrary, it is violative of Article 14 and consequently of Article 300A. I therefore do not think it is necessary to deal with them for ascertaining their respective ratios. Paragraphs 24 onwards, the next page. In this case, it is evident from the impugned decision that the authority has cancelled the lease in exercise of a right, the sole source whereof is the lease itself, a pure private law contract whose terms and conditions were binding on both the lessor and the lessee. Hence, correctness of the cancellation is not to be examined by the writ court in a public law remedy proceeding, applying the public law test of fairness, reasonableness, and non-arbitrariness state action enshrined in Article 14. The petitioner says private law remedy, if any, was before the civil court. I am unable to accept the argument that the authority has cancelled the lease by passing an executive order in exercise of its executive power. It is evident from the decision that the authority has cancelled the lease in exercise of its private law contractual right flowing solely from the terms and conditions of the lease. An authority, that is a state, within the meaning of Article 12, is under an obligation to exercise power conferred on it in consonance with the provisions of Article 14, meaning thereby that the action must be fair, reasonable, and free from arbitrariness. But in my opinion, the authority, when exercises a right conferred on it by a private law contract, is not under any corresponding obligation to exercise the right in consonance with the principle of fairness, reasonableness, and non-arbitrariness in state action enshrined in Article 14, for there is a clear distinction between a public law proper and a private law right. Public law power and a private law right. For these reasons, I dismiss the petition on the ground that it is not maintainable, and making it clear that nothing herein shall prevent the petitioners from approaching the civil court, no cause, certified xeroscopy. Now, this is first in the line with regard to maintainability of the writ petition. Then, my lord, is a judgment reported in 1993, volume 3 Supreme Court cases, page 499. Lord, I am placing reliance upon paragraphs 33 to 35 thereof.
Paragraphs?
33 to 35. Lord, this judgment has very longish paragraphs. Paragraph 33, you will, Lordship will find it at the end at page 546.
My lord, may I place it? On examination of some of these important decisions, it is generally agreed that legitimate expectations gives the applicant sufficient locus standi for judicial review, and that the doctrine of legitimate expectation is to be confined mostly to right of a fair hearing before a decision which results in negativing a promise of withdrawing an undertaking is taken. The doctrine does not give scope to claim relief straight away from the administrative authorities, as no crystallized right as such is involved. The protection of such legitimate expectation does not require the fulfillment of the expectation where an overriding public interest requires otherwise. In other words, where a person's legitimate expectation is not fulfilled by taking a particular decision, then the decision maker should justify the denial of such expectation by showing some overriding public interest. Therefore, even if substantive protection of such expectation is contemplated, that does not grant an absolute right to a particular person. It simply ensures the circumstances in which that expectation may be denied or restricted. A case of legitimate expectation would arise when a body by representation or by past practice aroused expectation which it would be within its power to fulfill. The protection is limited to that extent, and a judicial review can be within those limits. But as discussed above, a person who bases his claim on the doctrine of legitimate expectation in the first instance must satisfy that there is a foundation and thus has locus standi to make such a claim. If considering the same several factors which give rise to such legitimate expectation must be present, the decision taken by the authority must be found to be arbitrary, unreasonable, and not taken in public interest. If it is a question of a policy, even by way of change of old policy, the courts cannot interfere with the decision. In a given case where there are such facts and circumstances giving rise to a legitimate expectation, it would primarily be a question of fact. If these tests are satisfied, and if the court is satisfied that a case of legitimate expectation is made out, then the next question would be whether failure to give an opportunity of hearing before the decision affecting such legitimate expectation is taken has resulted in failure of justice, and whether on that ground the decision should be quashed. If that be so, then what should be the relief is again a matter which depends on several factors. We find in Attorney General versus New South Wales case that the entire case law on the doctrine of legitimate expectation has been considered. We also find that on an elaborate and erudite discussion, it is held that the court's jurisdiction to interfere is very much limited, and much less in granting any relief in a claim based purely on the ground of legitimate expectation. In Public Law and Politics, edited by Carol Harlow, we find an article by Gabriel Gans in which the learned author, after examining the views expressed in the case decided by eminent judges to whom we have referred to above, concluded thus: the confusion and uncertainty, I will not trouble your lordship with regard to that quotation. However, it is generally accepted and also clear that legitimate expectation being less than right operates in the field of public and not private law, and that to some extent such legitimate expectation ought to be protected though not guaranteed. My next paragraph, page 30, paragraph 35. Legitimate expectations may come in various forms and owe their existence to different kinds of circumstances, and it is not possible to give an exhaustive list in the context of vast and fast expansion of the governmental activities. They shift and change so fast that the start of our list would be obsolete before we reach the middle. By and large, they arise in cases of promotions which are in normal course expected, though not guaranteed by way of a statutory right, in cases of contracts, distribution of largesse by the government, in somewhat similar situations. For instance, discretionary grant of license, permits, or the like carry with it a reasonable expectation, though not a legal right, to renewal or non-revocation. But to summarily disappoint that expectation may be seen as unfair without the expectant person being heard. But there again, the court has to see whether it was done as a policy or in the public interest, either by way of GO, rule, or by way of a legislation. If that be so, a decision denying a legitimate expectation based on such grounds does not qualify for interference unless in a given case the decision or action taken amounts to an abuse of power. Therefore, the limitation is extremely confined, and if and if according to the, I don't know what it was, according of natural justice does not condition the exercise of the power, the concept of legitimate expectation can have no role to play, and the court must not usurp the discretion of the public authority, which is empowered to take decisions under law, and the court is expected to apply an objective standard which leaves to the deciding authority the full range of choice which the legislature is presumed to have intended. Even in a case where the decision is left entirely to the discretion of the deciding authority without any such legal bounds, and if the decision is taken fairly and objectively, the court will not interfere on the ground of procedural fairness to a person whose interest based on legitimate expectation might be affected. For instance, if an authority who has full discretion to grant license prefers an existing license holder to a new applicant, the decision cannot be interfered with on the ground of legitimate expectation entertained by new applicant applying the principles of natural justice. It can therefore be seen that legitimate expectation can at the most be one of the grounds which may give rise to judicial review, but the granting of relief is very much limited. It would thus appear that there are stronger reasons as to why the legitimate expectation should not be substantively protected than the reasons as to why it should be protected. In other words, such a legal obligation exists whenever the case supporting the same in terms of legal principles of different sorts is stronger than the case against it. As observed in Attorney General, to strike down the exercise of administrative power solely on the ground of avoiding the disappointment of the legitimate expectations of an individual would be to set the courts adrift on a featureless sea of pragmatism. Moreover, the notion of a legitimate expectation falling short of a legal right is too nebulous to form a basis for invalidating the exercise of a power when its exercise otherwise accords with law. If a denial of a legitimate expectation in a given case amounts to denial of right guaranteed or is arbitrary, discriminatory, unfair or biased, gross abuse of power, a violation of principles of natural justice, the same can be questioned on the well-known grounds attracting Article 14. But a claim based on mere legitimate expectation without anything more cannot ipso facto give a right to invoke these principles. It can be one of the grounds to consider, but the court must lift the veil and see whether the decision is violative of these principles warranting interference. It depends very much on the facts and the recognized general principles of administrative law applicable to such facts, and the concept of legitimate expectation, which is the latest recruit to a long list of concepts fashioned by the courts for the review of administrative action, must be restricted to the general legal limitations applicable and binding the manner of the future exercise of administrative power in a particular case. It follows that the concept of legitimate expectation is not the key which unlocks the treasury of natural justice, and it ought not to unlock the gates which shuts the court out of review on the merits, particularly when the element of speculation and uncertainty is inherent in that very concept. As cautioned in Attorney General, the court should restrain themselves and restrict such claims duly to legal limitations. It is well meant caution, otherwise a resourceful litigant having vested interest in contracts, licenses, etc., can successfully indulge in getting welfare activities mandated by directive principles thwarted to further his own interest. The caution, particularly in the changing scenario, becomes all the more important. In view of our conclusion, respect of the quantities allotted, 36. I did not press that. But then, my lord, is 2015, volume 1 Supreme Court cases, page 558. Eta diye din judge.
Page
558. 558. But I am placing reliance upon paragraphs 37, 39, 41, 43, and then 53 to 55. Paragraph 37 is at page 576. May I read it for you? It is well settled that whenever the government dealt with the public establishment in entering into a contract or issuance of license, the government could not act arbitrarily on its sweet will, but must act in accordance with law, and the action of the government should not give the smack of arbitrariness. In Ramana Dayaram Shetty, my lord, judgment has been quoted. This court observed that, my lord, this is, my lord, I'll just read this judgment, my lord. Dayaram Shetty is an important judgment of the Honorable Supreme Court, paragraphs 11 and 12. Today, the government in a welfare state is the regulator and dispenser of special services and provider of a large number of benefits, including jobs, contracts, licenses, quotas, mineral rights, etc. The government pours forth wealth, money, benefits, services, contracts, quotas, and licenses. The valuables dispensed by the government take many forms, but they all share one characteristic. They are steadily taking the place of traditional forms of wealth. These valuables, which derive from relationship to the government, are of many kinds. They comprise social security, benefits, cash grants for political sufferers, and the whole scheme of the state and local welfare. Then again, thousands of people are employed in the state and the central governments and local authority. Licenses are required before one can engage in many kinds of business or work. The power of giving licenses means power to withhold them, and this gives control to the government or to the agents of the government on the lives of many people. Many individuals and many more businesses enjoy largesse in the form of government contracts. These contracts often resemble subsidies. It is virtually impossible to lose money on them, and many enterprises are set up primarily to do business with the government. Government owns and controls hundreds of acres of public land valuable for mining and other purpose. These resources are available for utilization by private corporation individuals by way of lease or license. All these mean growth in the government largesse, and with the increasing magnitude and range of governmental function, as we move closer to a welfare state, more and more of our wealth consists of these new forms. Some of these forms of wealth may be in the nature of legal rights, but the large majority of them are in the nature of privileges. But on that account, can it be said that they do not enjoy any legal protection? Can they be regarded as a gratuity furnished by the state, so that the state may withhold, grant, or revoke it at its pleasure? It must therefore be taken to be the law that where the government is dealing with the public, whether by way of giving jobs or entering into contracts or issuing quotas or licenses or granting other forms of largesse, the government cannot act arbitrarily at its sweet will and, like a private individual, deal with any person it pleases. But this action must be in conformity with the standard and norms, which is not arbitrary, irrational, or irrelevant. The power or discretion of the government in the matter of grant of largesse, including award of jobs, contracts, quotas, licenses, etc., must be confined and structured by rational, relevant, and non-discriminatory standard or norm. And if the government departs from such standard or norm in any particular case or cases, the action of the government would be liable to be struck down, unless it can be shown by the government that the departure was not arbitrary but was based on some valid principle, which in itself was not irrational, unreasonable, or discriminatory. Then, my lord, Akhil Bharatiya 37, then 39, my lord. 39 is it has been quoted from Kasturi Lal's case reported in 1980, volume 4, Supreme Court cases, page 1. Paragraph 14 of the said judgment has been quoted, my lord. Where any governmental action fails to satisfy the test of reasonableness and public interest discussed above, and is found to be wanting in the quality of reasonableness or lacking in the element of public interest, it will be liable to be struck down as invalid. It must follow as a necessary corollary from this proposition that the government cannot act in a manner which would benefit a private party at the cost of the state. Such an action would be both unreasonable and contrary to public interest. The government therefore cannot, for example, give a contract or sell or lease out property for a consideration less than the highest that can be obtained for it, unless, of course, there are other considerations which render it reasonable and in public interest to do so. Such considerations may be that some directive principle is sought to be advanced or implemented, or that the contract of the property is given not with a view to earning revenue, but for the purpose of carrying out a welfare scheme for the benefit of a particular group or section of people deserving it, or that the person who has offered a higher consideration is not otherwise fit to be given the contract of the property. We have referred to these considerations only illustratively for there may be an infinite variety of considerations which may have to be taken into account by the government in formulating its policies, and it is on a total evaluation of various considerations which have weighed with the government in taking a particular action, that the court would have to decide whether the action of the government is reasonable and in public interest. But one basic principle which must guide the court in arriving at its determination on this question is that there is always a presumption that the governmental action is reasonable and in public interest, and it is for a party challenging its validity show that it is wanting in reasonableness or it is not informed with public interest. This burden is a heavy one, and it has to be discharged to the satisfaction of the court by proper and adequate material. The court cannot lightly assume that the action taken by the government is unreasonable or without public interest, because, as we said above, there are a large number of policy considerations which must necessarily weigh with the government in taking action, and therefore the court would not strike down governmental action is invalid on this ground unless it is clearly satisfied that the action is unreasonable or not in public interest. But where it is so satisfied, it would be the plainest duty of the court under the Constitution to invalidate the governmental action. This is one of the most important functions of the court and also one of the most essential for preservation of the rule of law. It is imperative in a democracy governed by the rule of law that governmental action must be kept within the limits of the rule of law, and if there is any transgression, the court must be ready to condemn it. It is a matter of historical importance that there is a tendency in every government to assume more and more powers, and since it is not an uncommon phenomenon in some countries that the legislative check is getting diluted, it is left to the court as the only reviewing authority under the Constitution to be increasingly vigilant to ensure observance within the rule of law, and in this task the court must not flinch or falter. It may be pointed out that this ground of invalidity, namely that the governmental action is unreasonable or lacking in the quality of public interest, is different from that of mala fides, though it may in a given case furnish evidence of mala fides. Now, the second limitation, this is also important, my lord, on the discretion of the government in the grant of legacies is in regard to the person to whom such largesse may be granted. It is now well settled as a result of the decision of this court in Ramana Dayaram Shetty that the government is not free like an ordinary individual in selecting the recipients for its largesse and cannot choose to deal with any person it pleases in its absolute and unfettered discretion. The law is now well established. The government need not deal with anyone, but if it does so, it must do so fairly, without discrimination, without unfair procedure. Where the government is dealing with the public, whether by way of giving jobs or entering into contracts or granting other forms of largesse, the government cannot act arbitrarily at its sweet will and like a private individual deal with any person it pleases. But its action must be in conformity with some standard or norm which is not arbitrary, irrational or irrelevant. The governmental action must not be arbitrary or capricious, but must be based on some principle which meets the test of reason and relevance. Now, thereafter, my lord, I am placing reliance upon paragraph 41. So, several judgments of the Honorable Supreme Court were taken into consideration in this judgment. In Sachidanandan Pandey versus State of West Bengal, this court, after considering various decisions on this point, came to the following conclusions. On consideration of the relevant cases cited at the bar, the following proposition may be taken as well established. State-owned or public-owned property is not to be dealt with at the absolute discretion of the executive. Certain precepts and principles have to be observed. Public interest is the paramount consideration. One of the methods of securing the public interest when it is considered necessary to dispose of a property is to sell the property by public auction or by tables. Though that is the ordinary rule, it is not an invariable rule. There may be situations where there are compelling reasons necessitating departure from the rule, but then the reasons for the departure must be rational and should not be suggestive of discrimination. Appearance of public justice is as important as doing justice. Nothing should be done which gives an appearance of bias, jobbery or nepotism. And paragraph 43, this is Center for Public Interest Litigation's judgment has been quoted. That is 2002, volume 7, Supreme Court case 564. The state is empowered to distribute natural resources. However, as they constitute public property, national asset, while distributing natural resources, the state is bound to act in consonance with the principles of equality and public trust, and ensure that no action is taken which may be detrimental to the public interest. Like any other state action, constitutionalism must be reflected at every stage of the distribution of natural resources. In Article 39B of the Constitution, it has been provided that the ownership and control of the material resources of the community should be so distributed so to best subserve the common good, but no comprehensive legislation has been enacted to generally define natural resources and a framework for their protection. Of course, environmental laws enacted by parliament and state legislatures deal with specific natural resources, that is forest, air, water, coastal zone, etc. Thereafter, Jamshed Hormuzji Wadia case has been quoted. This court held that the state's actions and the actions of its agencies, instrumentalities must be for the public good, achieving the objects for which they exist, and should not be arbitrary or capricious. In the field of contracts, the state and its instrumentalities should design their activities in a manner which would ensure competition and non-discrimination. They can augment their resources, but the object should be to serve the public cause and to do public good by resorting to fair and reasonable methods. Thereafter, paragraph 43, which is appearing at page 53. I'm sorry, 53, which is the last page, my lord. At page 585. My lord, the humanities judgment has been quoted here. You are not there. My lord,
for a private party.
My lord, I told my lord.
Hearing his argument.
My lord, I started my argument because my learned senior friend was not there, that I will be making argument against my own alter ego. But just came in any thought that I am argument against myself only. My lord, at the end of the day, what is to be seen is to whether by entering into a contract with a private entity by my own alter ego, whether that contract is against the public interest or not. And what they have challenged is cancellation of a lease in a writ proceeding. My lord, in Humanity versus State of West Bengal, this court observed that in the matter of granting largesse, the government has to act fairly and without even any semblance of discrimination. It was held as under. It is axiomatic that in order to achieve a bona fide end, the means must also to justify the end. The court is of the opinion that bona fide ends cannot be achieved by questionable means, especially when the state is involved. This court has not been able to get any answer from the state why, on a request by the allotted to the Honorable Minister for Urban Development, the government granted the allotment with remarkable speed and without considering all aspects of the matter. This court does not find any legitimacy in the action of the government, which has to act within the discipline of the constitutional law explained by this court in a catena of cases. We are sorry to hold that in making the impugned allotment in favor of the allottee, in the facts and circumstances of the case, the state has failed to discharge its constitutional role. Then, my lord, we take serious note and express our anguish the way the authorities of CIDCO showed undue favor to the respondents and managed to allot the government land in favor of one person, knowing fully well that the aforesaid proprietor of the company in different capacity and in dummy names sought allotment of plots. The way CIDCO has been dealing with the government property, it is high time we observe that, notwithstanding Regulation 4, as contained in the regulations, the appellant CIDCO may make all endeavor to make allotment of plots by open tender or competing biddings and shall not take any decision for allotment of the government land at the instance of the ministers and high dignitaries for any purpose whatsoever. Taking into consideration the entire facts of the case and the law discussed here and above, we have no hesitation in holding that CIDCO was justified in cancelling all the allotments made in favor of the respondents. Paragraph 54, the Honorable Supreme Court came down heavily upon CIDCO that you have allotted the land at the dictates of the ministers. And in paragraph 55, the same Honorable Supreme Court said, my lord, that CIDCO has done the right thing by cancelling the allotment. by undoing the wrong. এটা সিট কো বললাম ওকে না না ওটা হিউম্যানিটি ছেড়ে দাও না ওটা আমি জানি
I got the PIL in High Court.
Ah.
That was a PIL and Saurabh Ganguly's land allotment was challenged in there. That was a PIL where the allotment of land in favor of Mr. Saurabh Ganguly was challenged.
My learned
I had
friend
the
who is
occasion to
advocate-
appear
my
for the
learned-
petition.
he's an advocate lawyer. Well, I know that he appeared. Well, he will get his chance to deal with all my judgments. Ah. Well, 2018 volume 12 Supreme Court cases, page 85. 2018 volume 12 Supreme Court cases, page 85. And I am placing reliance upon paragraphs 23, 25 and 33. My lord, paragraph 23 is at page 100. At the bottom, my lord. Lord, it is no longer res integra that a public authority, be a person or an administrative body, is entrusted with the role to perform for the benefit of the public and not for private profit. And when a prima facie case of misuse of power is made out, it is open to a court to draw the inference that unauthorized purposes have been pursued if the competent authority fails to adduce any ground supporting the validity of his conduct. Then paragraph 25, the next page. In re, the duties, responsibilities and obligations of a public authority in a system based on rule of law, unfettered discretion or power is an anathema, as every public authority is a trustee of public faith and is under a duty to hold public property in trust for the benefit of the laity and not for any individual in particular. The following excerpt from Folks administrative law has been quoted. A true trust exists when one person, the trustee, is under a duty to hold the trust property vested in him for the benefit of other persons, the beneficiaries. The term trust is, however, used in a much wider sense. We may speak of government being entrusted with power of parliament as the trustee which the nation has authorized to act on its behalf. The purpose of use of the concept in such context is, of course, to emphasize that the powers and duties of such bodies should be exercised not for the advancement of their own interest, but that of the others, to underline their obligation to others. Paragraph 33, the last paragraph. Jurisprudentially, thus, as could be gleaned from the above legal enunciations, a public authority in its dealing has to be fair, objective, non-arbitrary, transparent, and non-discriminatory. The discretion vested in such an authority, which is a concomitant of its power, is coupled with duty and can never be unregulated or unbridled. Any decision or action contrary to these functional precepts would be at the pain of invalidation thereof. The state and its instrumentalities, be it a public authority, either as an individual or a collective, has to essentially abide by these inalienable and non-negotiable prescriptions and cannot act in breach of the trust reposed by the polity and on extraneous considerations. In exercise of uncontrolled discretion and power, it cannot resort to any act to fritter, squander, and emasculate any public property, be it by way of state largesse or contracts, etc. Such outrages would clearly be unconstitutional and extensive of the rule of law, which forms the bedrock of the constitutional order. The last, my lord, is 1973, volume 2, Supreme Court cases, page 650. This is a service law case, my lord. I'm placing reliance upon only one paragraph, that is paragraph 37. The High Court, has your lordship got that one? It's at page 660. Paragraph 37.
Yes.
May I read it for your lordship? The High Court was correct in holding that no estoppel could arise against the state in regard to abolition of post. The appellant Ramanatha Pillai knew that the post was temporary. In America jurisprudence at page 783, paragraph 123, it is stated, generally a state is not subject to an estoppel to the same extent as in an individual or a private corporation. Otherwise, it might be rendered helpless to assert its power in government. Therefore, as a general rule, the doctrine of estoppel will not be applied against the state in its governmental, public, or sovereign capacity. An exception, however, arises in the application of estoppel to the state where it is necessary to prevent fraud or manifest injustice. The estoppel alleged by the appellant was on the ground that he entered into an agreement and thereby changed his position to his detriment. The High Court rightly held that the
Then after my lord is coming back.
My learned counsel for the respondents.
কালকে কি করে
Paragraph
স্পেশাল ফিস করা থাকে
3 দিন বলেছেন হ্যাঁ
18th August 3:30 কিছু আছে কোনো কি দেখি
আমি কোথায় যাবো এখন কি করে
18th August.
কালি ফিক্সড ইফ আই মিন
Sir, I'll just check if there is any other matter.
কারেকশনাল ম্যাটারটা আছে তো
I mean, difficulty my lord always accommodate. Because now the circuit will continue up to October.
Yes, and back to back.
So that's why
3:30 কিছু নেই তো। So 18th 3:30.
প্লিজ ওটাই মার্কিং করা স্টপ
18th August.
same
marked
position,
at
same
3:30.
time.
Marked at 3:30.